Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
You're here for your arraignment. It is 1 count of trespass on a property after warning. That's a first-degree misdemeanor. Maximum penalty is 1 year in the Orange County Jail, $1,000 fine, or 1 year probation, any combination of the three. I show that you are represented by counsel. What are we doing with this one, counsel?
The offer is an adjudication of guilt, credit time served, no return to 1250 South John Young Parkway. There is cost of investigation in the amount of $103.90 to the Orlando Police Department. And Mr. Lester would like to accept an
Okay, it was $103.90?
Yes, Your Honor.
Right.
Orlando Police Department.
Got it. All right, sir. Your counsel has indicated you wish to change your plea and accept the state's offer to resolve your case. Is that correct?
Yes, sir.
All right. Being handed a plea form, so some rights listed on that plea form. Did you have a chance to go over this plea form with your attorney? All right. You understand that by resolving your case here today, you're waiving your right to go to trial?
Yes, sir.
All right. Are you on probation for any other offense?
Yes, sir.
All right. Do you understand that if you were on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yes, sir.
All right. You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes.
And do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, that a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right. Well, accept the no contest plea, adjudicate you guilty, sentence you to 27 days in the Orange County Jail with credit for the 27 days that you served. Order that you do not return to 1250 South John Young Parkway. We'll also impose court costs plus $103.90 cost of investigation to Orlando Police Department. We'll give you 1 year from the date of your release to pay that. If there's still after a year, if there's still a balance and you're not on a payment plan with the clerk, they're going to suspend your driver's license. Okay.
Thank you, sir.
All right. Any further questions?
Yes, sir.
All right. You have 30 days to appeal the judgment and sentence. Well, that's two. All right. All right. All right, sir. What's your name?
Anthony Harris.
All right, Mr. Harris. You're here on 1 count of trespass of property other than a structure or conveyance. Today's your arraignment. That's a first-degree misdemeanor. Maximum penalty is 1 year in the Orange County Jail, $1,000. You have an attorney, so I'm just...
I wasn't told I was going to work working. I was working on the job.
Listen. Today's just your arraignment. I understand if you got any defenses there, you want to talk about that with your attorney. Today, I'm just telling you what you're charged with. The maximum penalty is the state's going to make an offer. If you want to choose to accept the offer, you can do that, or you can go to trial and raise any of those defenses you want to do.
Okay, repeat what I have to do again now? Repeat it over. Repeat what you said over. You repeat it over?
Yeah. You want me to repeat?
Yes, sir.
Okay. All right. Today is your arraignment. Arraignment, the court just tells you what you're charged with, goes over the maximum penalties, some of your constitutional rights, including the right to go to trial, call your own witnesses, present any defenses, the right to an attorney. The Office of the Public Defender has already been appointed to represent you, so you have an attorney in this matter. And then the state's going to have an offer in your case, and you can choose to accept that offer, waive your right to go to trial and accept that offer, or you can maintain your not guilty plea and proceed to trial or any other resolution that you and your attorney discuss. But today's just your arraignment date to tell you what you're charged with, convey an offer, and see how you want to move forward. Okay? What's that?
What are you charged with?
That's what I'm telling you. That's what we're doing today. Okay?
Your Honor.
You said a year, but you said trespass is only 30 days.
No. Listen, I'm just telling you the maximum.
Oh.
I'm not telling you what you're being sentenced. I'm just telling you you're charged with trespass on property other than a structure or conveyance. In the state of Florida, that's a first-degree misdemeanor. The very maximum penalty you could get on that is 1 year in the Orange County Jail, $1,000 fine, 1 year probation, or any combination of the three. That's the maximum penalty. That's not your offer.
Trespass or trespassing?
Trespass.
Trespass.
Trespass on property other than a structure or conveyance.
Oh.
Was there an offer in this case?
Yes, Your Honor. State did convey an offer to Mr. Harris of an adjudication of guilt, credit time served, no return to 75 West Main Street in Apopka, and cost of investigation to Apopka PD in the amount of $117.38.
All right, sir. If you want to resolve your case here today, and I'm not asking you to say anything, I'm just talking to you right
Let's
now.
pass, let's resolve it.
Yeah, I'm gonna wait for your attorney to get back over there, but what the state's offer to resolve your case here today
Yeah.
is a no contest plea or a guilty plea. In
No
exchange,
contact.
hold on, in exchange for an adjudication of guilt, so you'd be convicted of the trespass, sentenced to 27 days in the Orange County Jail with credit for the 27 days that you've already served, you'd be getting out today. Plus, oh, you won't be getting out today. You'd be released only as it relates to this charge. If there's
Why won't we get out today?
there's something else holding you.
What's holding me?
He only has 2 days on this case.
Oh,
What's holding me?
What case is he being held on?
22 CF 9776 AO, and that wasn't transferred.
hold on one
That's
second.
the case he got arrested on previously.
Oh, but that's drop. So this time, sir, it's over.
Bat Leo resisting with.
All this drop, mom, the time it's over.
Counsel, I mean, I don't know if you know, but was this, these were separate offenses? The CF case is related to the trespass?
Yes, they were, Your Honor.
They're related?
They're completely unrelated.
Oh, unrelated?
Yes.
Okay.
I have nothing on me, nothing on me. I'm on this time, sir, everything done. This time, it was it.
And I'm gonna enter,
That's how I'm on.
I'm gonna enter a plea of not guilty.
Yeah. All right. So we're going to maintain a not guilty plea. You're just here on your trespass case here today. You've also got a related or an unrelated case of resisting an officer with violence. That's also holding
Oh,
you.
no, I could just.
I'm not, no. I don't want to ask you about the facts of your case. Today's not your trial. Anything you say can and will be used against you. So today we're just going to enter a not guilty plea on your trespass case. You still have a bond on that case, right?
He does.
Yes, Your Honor.
You still have a bond on that case. But you're also being held on a felony case that's not before the court.
I never did a felony.
That issue's not before the court today. You have the public defender appointed to represent you on both of your cases.
What day is that? What day is
Your
it?
pretrial date is September 23rd at 9 o'clock in courtroom 6B.
There you go.
Division 81.
That's your pretrial date. Your next court date, your attorney will probably be in contact with you soon, okay?
Leave for today? Free to go?
Yeah,
Okay.
that way. I hear you. All right, man, what's your name? Oh, do we want to do, we're doing all of them. All right. All right, Ms. Wilkes, you're here on a warrant for failure to appear. That warrant was signed by Judge downtown, has a $1,000 bond. Court's going to stay that bond, so you're going to be held on $1,000 bond on the failure to appear, okay? Well, I'm going to appoint the public defender's office to represent you, so you have an attorney. Understand that everything you say can and will be used against you.
And again, you failed to appear. You're off. So you're gonna have to call that. You failed to appear. You didn't.
I ain't not going out.
All right, sir, what's your name? All right, Mr. Gore, you're here on one count of violation of the city ordinance against camping. Is there an offer to resolve this case?
Yes, Your Honor. State did convey an offer on behalf of the city to Mr. Gore of a withhold of adjudication, credit time served.
All right, you're currently being held on you currently have bond of $250. If you want to resolve your case here today, the city's conveyed an offer of a withhold of adjudication, credit time served, so you'd be released as it relates to this charge today without having to post a bond, or you can maintain your not guilty plea and proceed forward on a criminal trial docket. What would you like to do? I'll appoint the office of the public defender to represent you as well. All right, what you're signing is a plea form. It's got some rights listed on top of that plea form associated with going to trial, including the right to call witnesses, the right to present your own evidence, the right to have the right to go to trial, have the state prove the crime against you, the right to an attorney. By resolving your case here today, you understand that you're waiving the rights associated with going to trial and there's not going to be a trial? All right, you under the influence of any drugs, alcohol, or medications affecting your ability to understand what's happening here today? All right, you understand if you're not a U.S. citizen, a plea to this offense would subject you to deportation? All right, is this your signature at the bottom of the plea form? You understand if you've ever been convicted of a sexually motivated or sexually violent offense, that a plea to this offense could subject you to involuntary civil commitment? All right. You on probation for any other offense? Are you aware that if you are on probation for a separate offense, that a plea to this offense might be used to violate that probation? All right, we'll accept the no contest plea, adjudicate you guilty, assess the mandatory court costs.
It was a withhold, Your Honor.
Oh, it was. We'll withhold adjudication, so there's technically not a conviction. We'll withhold adjudication, assess the mandatory court costs. How many days do you have? 2?
2 days.
Yeah. Sent you to 2 days in the Orange County Jail with credit for the 2 that you already served, so you'll be released as it relates to this charge today, okay? All right, we'll give you 1 year to pay, 1 year from the date of your release to settle up the court costs, all right? You have 30 days to appeal the judgment and sentence. Other than that, you have to step outside, wait for your paper, or step outside that door, okay? All right, man, what's your name?
Selena Thompson.
All right, Ms. Thompson, give me 1 second.
Yes, sir.
All right, you're here on 1 count of possession of MDMA, 1 count of possession of drug paraphernalia. You're also out on bond, or you're awaiting pretrial diversion in a separate case for possession of cocaine. I'll appoint the Office of the Public Defender to represent you. I'm going to state, do you have a recommendation as to appropriate bond? The court's inclined to stay him at 1,100.
Your Honor has no, state has no objection to that.
Okay. We're going to set your bonds in your new case of count 1 of 1,000, count 2, it's going to be $100. In the case that you were referred to PTD, we're going to set your bond in that case at $100 as well, okay? So
You're revoking the R.
revoking the ROR, and we're going to set a bond on that case, okay? Actually, no, we'll reinstate the ROR on that case. Can we-
No action.
No action on the case she was in PTD. She's gonna have to bond out on these, so. PTD, they can figure that out. We'll take no action on that one. All right. Thank you. Okay. What do I do with the Spanish folks? Here they are.
Good morning, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Good afternoon, Mr. Interpreter. We have 2 who require the services of the interpreter. The first individual does have the headset on.
Your Honor, the interpreter can confirm there is connection.
All right, sir, what is your name?
Jose Fernandez.
Jose Fernandez.
All right, Mr. Fernandez, you came in on 1 count of video voyeurism on a child less than 16 years of age. You came in on a warrant with a $5,000 bond. I'm going to appoint the Office of the Public Defender to represent you. At this point, we'll stay the bond at $5,000 unless there's any objection from the state.
No, Your Honor, given he has no other criminal history.
So your bond's going to be stayed at $5,000. You have a step outside that door, okay?
And Your Honor, may the interpreter ask for the CF case number?
Yes, it is 2022 CF 8726. Oh,
Thank you, Your Honor.
All right, ma'am, what is your name?
Lady Viviana Mora Leon.
Lady Viviana Mora Leon.
Okay, this is case number 2022 CF 10117AO. It's one count of grand theft, third degree, one count of possession of anti-shoplifting device. Reviewed the arrest affidavit. It's determined there is probable cause. I'm going to appoint the public defender to represent you. Set bond at count one of $1,000. Count two, $100. Is there anything further from the state?
Your Honor, state would ask for a no return to the Macy's.
Also ordered that you do not return to the Macy's. All right, thank you.
In the honor, may the interpreter be excused this moment.
Yes, I believe so. Thank you very much.
Thank you, Honor. Have a great day.
Bye-bye. All right, sir, what's your name?
Tyreek Dallas.
King's not coming? I don't.
Brian King.
Brian King, is he?
What's the inmate number?
That's an arraignment.
It's an arraignment, 2202.
Oh, no. Never mind. I'm sorry, Your Honor.
Okay, all right. Let's set him to the side. All right, what's your name?
Tyreek Dallas.
Dallas?
Yes, sir.
I don't remember seeing a Tyreek Dallas.
Arraignment.
Oh, okay. I got you. He pled? All right, clerk showing that there was a previous plea entered on Monday of this week.
Yeah,
He already pled to that.
Okay.
I don't know why.
Well, wasn't a time served offer, I hope, or what, let's see. What's the case number?
2020 CT.
CT 6398,
Not held on anything else.
2020.
Did you plead to that one?
He has a hold,
Okay,
out of county hold.
all right. So you resolved your case here in Orange County. They're still hold on you for an out of county. So I guess they can't release you until that hold gets lifted or you get transported to that other county, okay?
This case should be closed.
Yeah, it
This
is.
case should be
So
closed.
he shouldn't have been brought here.
So I'm just sitting until Lake County come get me?
Right.
Yeah.
They can't release you until that hold gets lifted, until that other county comes and gets you, okay?
You know how long I'll be sitting, like 14 days?
You want to talk to your attorney. You have an attorney, so,
I tried to bond now, the bail bond told me I have to sit for 14 days till Lake County come get me. If they don't come get me, I have to leave.
That I don't.
yeah, good luck to you. All right, sir, what's your name?
Brian King.
All right, Mr. King, you're here for an arraignment, driving while license suspended with knowledge. That's a second-degree misdemeanor. Maximum penalties, 60 days in the Orange County Jail, 6 months probation, $500 fine, or any combination of the three. State, is there an offer in this case?
Yes, Your Honor, state did convey an offer to Mr. King of an adjudication credit time served, and I do not believe this will HTO him.
Has anything else?
Battery DV.
100? 500? Do you still have to?
All right, Mr. King, I was handed a plea form. It's my understanding you want to accept the state's offer and resolve your case here today?
Yes, sir.
All right, just let me look at something real quick. Has anyone ever explained to you habitual traffic offender?
Not completely, no.
All right, well, I'll do my best. In the state of Florida, if you get three qualifying offenses. What's it, 3751? You get three qualifying, if you're convicted of, three qualifying offenses within 5 years, you qualify for what's called, habitual traffic offender, and your license gets revoked for 5 years. If you get caught driving on that revoked license, it's a third-degree felony punishable by up to 5 years in prison. Your third driving while license suspended, even though it's not a felony, is there's mandatory jail time on that in 10 days. So the moral of the story is either fix your license or quit driving if you keep getting caught. And I don't know how they know, but trust me, they know. The deputies out there, they know when your license is suspended. They will pull you over, and they'll keep catching you. So the more times you get pulled over, the penalties get worse and worse and worse. So if you, I don't believe I have a yeah.
Your Honor,
Just-
he has a fairly lengthy driving history. He had a 2018 HTO Dwellis he was adjudicated on. Currently has an open Palm Beach PTD Dwellis.
Okay.
He has this open orange, and then he at least has, I see at least 3 or 4 prior Palm Beach and orange Dwellises, 2016, 2017, 2018.
So
It's a,
I can't tell you what to do. I can just explain to you what habitual traffic offender is. So a plea to this offense is a qualifying offense. You would be released today, but it'd also be a strike on your HTO. You've got those other ones going on. You know, the state in those cases may decide to upcharge those and file them as felonies, and you know, it's up to you. So knowing that, you still want to resolve this case here today?
Sir.
All right. I was handed a plea form. Do you have a chance to go over this plea form?
Sir, it's time, sir.
Yes. You understand that by resolving your case here today, there's not going to be a trial?
Sir.
All right, you understand if you're on probation for a separate offense, a plea to this offense will violate that, or might be used to violate that probation? Do you understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Sir.
Do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right, you under the influence of any drugs, alcohol, medications affecting your ability to understand what's happening here today?
No, sir.
Anyone threaten you or coerce you to enter this plea?
No, sir.
All right, we'll accept the no contest plea, adjudicate you guilty, sentence you to 4 days in the Orange County Jail with credit for the 4 days that you've already served. I'll also assess mandatory court costs and give you 1 year from the date of your release to pay that, okay? If you don't pay and you're not on a payment plan after a year, there's going to be another suspension on your driver's license, just one more thing to clean, you know, another mess for you to clean up, okay? All right. Have 30 days to appeal. Have to step outside.
Thank you. Y'all have a good day.
You too.
Your Honor, Charles Kaufman is medical.
All right, so we just enter a not guilty plea? Is that what we do? Yeah. Oh, he's got an attorney, so you want to just enter a not guilty plea, waive his appearance, counsel?
Yes, Your Honor.
All right.
It'll be Division 61. Pretrial will be September 23rd at 9 o'clock in courtroom 7C. Anna Crawford is mental health.
All right, same thing with Ms. Crawford?
Yes, Your Honor.
All right, we're in a plea of not guilty.
Division 61, September 23rd at 9 o'clock in courtroom 7C.
All right, sir, what's your name? All right, Mr. Davis, you are represented by counsel, so just be aware that anything you say can and will be used against you. If you want to speak to the court, it's usually the best idea to run it through your attorney, okay? But you're here on an arraignment. An arraignment just, we'll just tell you the maximum, what's, You're here on one count of disorderly conduct, one count of resisting an officer without violence. What are we doing with this one?
Your Honor, state did convey an offer on behalf of the city of an adjudication of guilt, credit time served, a $10 filing fee, and court costs.
And Mr. Davis would like to accept an enter plea of no contest, Your Honor.
All right, so it's a no contest plea to both counts
Yes, Your Honor.
and adjudication on both counts?
Yes, Your Honor.
All right. All right, the document you're signing, it's a plea form. There's some rights listed on that plea form that are associated with your right to go to trial. Your right to be represented by counsel, right to call your own witnesses, confront the state's witnesses, present your own evidence, have the state prove the charges against you. You understand that by resolving your case here today that you're not going to trial and that you're waiving the rights that are listed on this plea form? All right. So you under the influence of any drugs, alcohol, or medications affecting your ability to understand what's happening here today? Has anyone threatened you or coerced you to enter this plea?
No.
You understand that if you are on probation for a separate offense, that a plea to this offense might be used to violate that probation?
Yes,
Yeah, if you're not on probation, doesn't apply to you, I'm just asking if you understand that.
I understand.
All right. You understand that if you're not a U.S. citizen, that a plea to this offense would subject you to deportation?
I understand.
Do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, that a plea to this offense could subject you to involuntary civil commitment?
I understand.
All right, we'll accept the no contest plea as it relates to count one. We'll adjudicate you guilty, sentence you to 32 days in the Orange County Jail with credit for the 32 days that you've already served. Assess court costs plus a $10 filing fee. Give you 1 year from the date of your release to settle up the financial obligations or to be on a payment plan. With regards to count two, we'll just adjudicate you guilty on that with no further sanction.
Thank you, Your Honor.
All right, you have 30 days to appeal the judgment and sentence. You'll be released as to this charge today, okay?
Appreciate y'all. Have a wonderful day.
Yep. All right, sir, what's your name?
Scott.
All right, Mr. Scott. Shows here you're represented by counsel. Is that your understanding?
Yes.
See, he filed anything? He filed written plea not guilty? Let me look.
He did in the felony case. So
Yeah, we'll just do it.
but that was the, PD that filed it. This is like a private.
So the PD filed NOA on the felony?
Yeah, and I guess he substituted out
Okay,
his attorney.
let me just look at something real quick.
Sure.
All right, I see a written plea of not guilty was filed by your attorney prior to the information being filed. So without your attorney present, we're just going to maintain your not guilty plea. It was filed as a first-degree misdemeanor. You came in on an arrest affidavit on a felony charge. The state decided to file charges on a first-degree misdemeanor of improper exhibition of a dangerous weapon or firearm. We're going to maintain your not guilty plea. Just for the record, though, state, was there an offer in this case or
Not
no?
at this time, Your Honor.
State does not have an offer, so even if you wanted to, there's nothing to enter a plea to. But your private attorney, Mr. McChesney, had entered the PD had entered a written plea of not guilty. We see that your private attorney, you have a private attorney, so we're just going to maintain your not guilty plea at this time. Your next court date is going to be,
Convention 83, it's gonna be September 19th at 10:30 in courtroom 6C.
all right, let me see.
Could you please reiterate what's happening again?
Yeah, I've just told you what you're charged with. You're charged by information. The state filed charges as a misdemeanor. So we entered a not guilty plea on your behalf. You got another court date coming up. Today's just your arraignment where we tell you what you're charged with. Does he have bonds on the?
Looks like it's still the felony bonds.
Yeah.
What's the amount of the bonds?
10,000 on each count.
Okay. On each count?
So it's 20 total.
Any objection to doing a nominal bond on the, hold on, was there a second count even on the information? Let me go back.
We filed one.
No, Your Honor, we only
It's just
filed
one count?
one. I'm pulling history real fast, 1 second.
Now we're just looking, you came in with some felony bonds since the state's filed it as a misdemeanor.
So it was a felony and now it's a misdemeanor?
What's that? It came in as a felony. The charges the state filed on 8/24 is a first-degree misdemeanor. Maximum penalty on that's, it's one count. So maximum penalty on that is 1 year in the county jail, 1 year probation, or $1,000 fine, or any combination of the three. Any objection to deleting a bond on count 2 and just leaving a $10,000 bond as to the count that's filed on?
No objection, Your Honor.
Okay, so we're gonna delete the $10,000 bond on the count 2 that wasn't filed on, and we're gonna leave the $10,000 bond on the misdemeanor count, improper exhibition of a dangerous weapon or firearm, okay?
So you're gonna ROR the second.
I guess, yeah, ROR in the second, yeah. All right. All right, so, step outside, thank you. All right, sir, what's your name?
Ron Williams.
All right, Williams? All right, Mr. Williams, this is an arraignment for you as well. It's violation of a domestic violence injunction by communicating or contacting. You do have an attorney. You're represented by the Office of the Public Defender. State, was there an offer in this case?
No, Your Honor.
All right, because there's no offer in this case, we're just going to maintain your not guilty plea, okay? So next court date, you're just going to get another court date, all right?
Division 50, September 23rd at 9 o'clock in courtroom 4E.
All right, so that. All right, thank you. Alvarez?
He was set for a plea. He's not gonna be able to come tomorrow.
What happened to Kimberly?
Was Wilozinski?
I have her, they said they don't. I have her, they said it wasn't on the docket,
Kimberly
the
Wilzinski?
last person that we had.
We're all talking about different people.
I know, what, arraignments.
Yeah, I have one more arraignment on my, that's Kimberly Wilzinski. She's not listed, so want to set her for tomorrow, can we do that? Roll her.
I would just
or an
reset for
She's set
tomorrow.
for, I don't know, what do we do?
It's fine. We can reset to tomorrow.
Yeah, because she was set
Doesn't
for me too, I don't know. Can we reset for tomorrow, Your Honor?
Because it's a trespass, it's one of those that's likely to probably resolve, so.
Yes, Your Honor, there was an offer, so I just asked that it be reset for tomorrow.
All right, we'll reset that for in-jail arraignment tomorrow. Okay. All right, sir, what's your name?
I believe Alvarez Jonathan was restricted, Your Honor. He was set for a plea. I will have to waive I would just waive the appearance. He can't be brought up, so we'll have to do maybe a polycom plea or something. I'm not sure.
Okay, what division is he, Judge Allen? What's the offer?
Adjudication, credit time served, cost of investigation of $94.72 to Orlando Police Department, and no return to the 7-Eleven.
So if we reset that, I don't know, if we reset that in front of, just give our plea date in Judge Allen's division, is that easier to do it remotely, or is?
I'm not sure I'm not sure how it works.
I don't know. Like in my division, I mean, you maybe do a written plea too and just get fingerprints. I don't know. If it's credit time served, obviously the mission is
It's to
to
clear.
get him out as soon as possible, so, next week, why is he, is it, COVID or monkeypox or something like that?
Yeah, restricted.
So what's the protocol? Like how many days? Does it just depend? Yeah. Yeah, I know. We're just trying, I know we're all working in a brave new world, so.
I think the JA will reset it.
Just the JA reset? Okay.
I'll let the attorney know, yes, Your Honor.
Yeah, we'll say to be reset.
Thank you.
And then if, what we've done in our division is just if they can do a written plea and just have them fingerprinted on the way out, so you can let the other attorney, if a written plea is possible, that may be, sometimes that's the easiest way to do it when people are restricted, because like we discovered, who knows when they're gonna come off that list, so.
Thank you.
Now we're going down. All right, sir, what's your name? All right, Mr. Brown, you do have an attorney. It looks like it's set for a plea today. Is that correct, counsel?
Yes, Your Honor. The offer, Mr. Brown's here for a false, I believe it's a false information.
False ID to a Leo and resisting without.
Yes,
Yep.
and the offer is for the false information is an adjudication, credit time served. There is a cost of prosecution in the amount of $250, in court costs. As to the resisting an officer without violence, it's an adjudication, credit time served. There's also a cost of prosecution in the amount of $250. And Mr. Brown would like to accept both offers.
All right. Is it a cost of prosecution or a cost of investigation?
It's a fine, Your Honor.
Oh, it's a fine. Okay.
Oh,
So,
I'm sorry. I'm sorry.
that's all right. So it's a $250 fine on both counts.
On each
So a
count.
total $500 fine?
Yes, Your Honor.
Okay.
Okay, we're good.
All right, so, Mr. Brown, you heard what your attorney had to say. Is that your understanding of what's happening here today? I'm handed a plea form. It's got your name at the top. It appears to have your signature down at the bottom. Did you sign this plea form?
Yes, sir.
Did you have a chance to go over this plea form with your attorney?
Sir.
You understand that by resolving your case here today, you're waiving the rights listed on this plea form. There's not going to be a trial?
Yes.
All right. You on probation for any other offense? You understand that if you were on probation, that a plea to this offense, if you were on probation for a separate offense, that a plea to this offense might be used to violate that probation?
Sir.
You understand if you're not a U.S. citizen, a plea to this offense would subject you to deportation?
Yes, sir.
And do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right. You under the influence of any drugs, alcohol, or medication?
No, sir.
All right. Anyone threaten you or coerce you to enter this plea?
No, sir.
All right. We'll accept the no contest plea. Count one will adjudicate you guilty, sentence you to credit time served. How many days was it? Yeah. How many days is he on? You know?
I'm not sure.
I got like 46.
They have to do accurate.
$47.
All right. One more than you thought. So, yeah, sentence you to 47 days in the Orange County Jail with credit for the 47 days that you already served. We'll also assess court costs, cost of prosecution, plus a $250 fine. As count two, we'll accept the no contest plea, adjudicate you guilty, sentence you to 47 days in the Orange County Jail with credit for the 47 days that you've already served. We're not going to do court costs on that, but there will be a $250 fine. We'll give you 1 year from the date of your release to settle up the financial obligations or to be on a payment plan making regular payments. If you're not on a payment plan making regular payments and there's still a balance after a year, they'll suspend your driver's license, all right?
Yes, sir.
All right, anything further?
No, thank you, Your Honor.
All right, you should be released as of this case today. You have 30 days to appeal the judgment and sentence.
You're welcome.
All right, sir, what's your name?
Jamal Harris.
All right. All right, Mr. Harris. You're here on one count of trespass on property after warning. Say, was there an offer to resolve this case?
Yes, Your Honor, state convened an offer of an adjudication of guilt, credit time served, which will be 2 days, and no return to the Circle K BP gas station at 9999 South Orange Blossom Trail.
All right, Mr. Harris, you have the right to go to trial on this offense. You have the right to call your own witnesses, present evidence. You have the right to an attorney, all those things that are associated with going to trial. The state's offer to resolve your case here today is essentially a credit time served offer. It's an adjudication of guilt. 2 days in the Orange County Jail with credit for the 2 days that you've already served, plus a no return to the Circle K where this all happened, okay? What would you like to do?
No contest.
All right, so no contest plea?
Yeah.
All right. I'm handed a plea form. It's got your signature down at the bottom. you have a chance to read and go over this plea form? Yeah. All right. You understand that by resolving your case here today, there's not going to be a trial and you're waiving the rights listed on this plea form? Yeah. All right. You understand if you're not a U.S. citizen, a plea of this offense will subject you to deportation? Do you understand that if you are on probation for a separate offense, that a plea of this offense might be used to violate that probation? And do you understand that if you are ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense might be could subject you to involuntary civil commitment? Yeah. All right. We'll accept the no contest plea, adjudicate you guilty, send you 2 days in the Orange County Jail with credit for the time served. Assess court costs. We'll give you 1 year from the date of your release to settle the financial obligations. You have 30 days to appeal the judgment and sentence. Should be released as it relates to this charge today, okay?
All the things you want.
Because he doesn't have any history.
All right, so what,
Did you appoint the PD? Are you appointing the PDs on the
No.
police?
I didn't,
Oh, to this.
yeah. I didn't on the last one. I know you kind of went over the plea form with him, but I didn't appoint them officially. Save him $50.
Yes, thank you. I agree.
Yeah. All right, sir, what's your name? Richard King.
And, Your Honor, the offer to resolve was an adjudication of guilt, credit time served, no return to 6119 South Orange Blossom Trail. And Mr. King would like to accept and enter a plea of no contest.
All right, Mr. King. I was handed a plea form. Did you have a chance to read and go over this plea form? You understand that by resolving your case here today, there's not going to be a trial and you're waiving all the rights that are listed on this plea form? Yes, sir. All right. You under the influence of any drugs, alcohol, or medications affecting your ability to understand what's happening here today? No, sir. Anyone threaten you or coerce you to enter this plea? You understand that if you are on probation for a separate offense, a plea to this offense might be used to violate that probation? Do you understand that if you've ever been convicted of a sexually violent or sexually motivated offense, a plea to this offense might be, could subject you to involuntary civil commitment? Yes, sir. And that if you are not a U.S. citizen, a plea to this offense could subject, or would subject you to deportation. You understand that? All right, we'll accept the no contest plea, adjudicate you guilty, was it 2 days?
Yes, Your Honor.
All right. Sent you 2 days in the Orange County Jail with credit for 2 days' time served, so as it relates to this charge, you will be released today. Also order that you do not return to the Bel Air Hotel at 619 South Orange Blossom Trail. And I'll give you 1 year from the date of your release to settle up any of the financial obligations or else your license is going to be suspended, okay? All right. You have 30 days to appeal the judgment and sentence. Please have a step outside or follow the deputy. I'm sorry. All right, sir, what's your name?
Harry Ortiz.
All right, Mr. Ortiz, you're here on one count of, hold on 1 second.
Your Honor, understand that, I know the state was not making an offer to resolve, being that Mr. Ortiz was just released when, the 29th. However, I would, in this particular case, ask for a bench offer. He has no other criminal history other than the trespass.
Was the previous trespass at the same Walmart?
Yes, Your Honor.
Yeah, he believes, he's trying to spread the word of God, Your Honor.
Understand.
I just don't think it warrants him sitting in here. Given that he, other than these trespasses, he's never been in trouble. So I was asking for an
Yes.
offer to resolve the cases. We thought he would qualify for pretrial diversion, being that he didn't have any other criminal history, which is why we didn't resolve the first.
Well, he was out on PTR on a similar trespass.
Yes, we just saw
Right.
him.
Right.
He picked up that one 3 days ago, bonded out 2 days ago, picked up this one yesterday, and then he's here today. So both of these cases in 4 days.
And
All right. So there's two trespasses, correct?
Yes, Your Honor.
All right. If he wants to resolve both of them,
Your Honor, he can't resolve the other one. Information has not been filed.
so the one he's out on PTR on, there is an information filed?
There is not. He just picked that up 2 days ago.
Okay. And the one he's here on today,
It's pleable because he's at IA.
because he's at IA?
If
All
there's a
right, so
bench.
if you want to resolve the one that's here today, how many days, sir, he's got 2 days time served on this one?
Yes.
Here's what the court's willing to do. On the one that's pleadable here today, it'd be 20 days in the Orange County Jail. I would revoke the PTR, so he'd be being held on both of them. And then if he can negotiate some sort of resolution of that other one, it's my understanding the public defender's been appointed, but he would not be released as to the one today. It'd be 20 days in the Orange County Jail, just given the nature of going back to the same spot. And it'd also be upon your release, no return to that Walmart.
He's okay with the 20 days, Your Honor.
All right. So on 2022 MM 5940, that's the one we're here on today, correct?
Yes.
All right. Do you have a plea form, or did you filling that out now? All right. While you're doing that, we'll go ahead and revoke pretrial release on the other one. We'll give a $2,500 bond on that one. All right, sir. You have two open cases, both for essentially the same offense, just on different dates. Do you need that, or? Gotcha. I got you. The plea here today is just to the most recent trespassing. You understand that, correct? All right, so we're taking no action on the one that you were out on PTR on, other than revoking your pretrial release and instating a bond of $2,500. So on the one that you were out on bond on, you out on pretrial release, that's now being revoked. You're being held in the county jail on that one on a bond of $2,500, okay? You want to talk to your attorney about that. If you post that bond too soon, you're not going to get credit for the time served on that other case. Because on the case that you are here on today, the most recent one that you're here at initial appearance, the court's offer was 20 days in the Orange County Jail, and you wish to accept that, correct? Sir. All right, was handed a plea form by your attorney. Did you have a chance to read and go over this plea form? Do you understand that there are rights so did you have a chance to read the plea form or no? All right. On this plea form, the top part of this plea form, there's a number of rights listed on it that are associated with going to trial. The right to an attorney, the right to call witnesses, the right to confront the state's witnesses, the right to present your own evidence, the right to have the state prove the charges against you to a jury beyond a reasonable doubt. By signing the bottom of the plea form, it says that by resolving your case here today, you're waiving all those rights. Do you understand that? All right. You understand that if you are not a U.S. citizen, a plea to this offense would subject you to deportation? Yes? Okay, sorry. Sometimes I can't hear. It's okay.
Yes, Your Honor.
You understand that if you were on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yes, Your Honor.
You understand if you've ever been convicted of a sexually violent or sexually motivated offense, that a plea to this offense might be, or could subject you to involuntary civil commitment.
Yes, Your Honor.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today? All right. Has anyone threatened you or coerced you to enter this plea? All right. We'll accept the no contest plea. I'm going to adjudicate you guilty, sentence you to 20 days in the Orange County Jail with credit for 2 days' time served. A no return to the Walmart at 9047 Curry Ford Road. There's also court costs. We'll give you 1 year from the date of your release to settle up the court costs or be on a payment plan making regular payments. If you're not on a payment plan making regular payments and there's still a balance after a year, the clerk's going to administratively suspend your driver's license, okay?
Just until the payment's finished off and I get my driver's license back?
Yeah. Yeah. All right, so thank you. You have 30 days to appeal the judgment and sentence.
Your Honor, Jorge Ortiz is now held.
Can we reset for tomorrow, Your Honor? There's an offer to resolve.
I'll appoint the public defender to represent him. If he's mental health,
I didn't see any, based on what I could see, I didn't see any competency. It looks like he just pled, also, which is what I saw in Odyssey, so I would ask that he be reset for tomorrow, at least to give him the opportunity to plea, Your Honor.
all right. We'll reset that till tomorrow. I mean, mental health's a little different than restricted, so yeah, we'll reset it till tomorrow. Okay, and PD is appointed.
Thank you.
Reginald Stanford bonded.
Bonded? Okay. All right, man, what's your name?
Troy Thomas.
All right, Ms. Thomas. You're here on one count of resisting an officer without violence. I've reviewed the arrest affidavit. I'll appoint the public defender's office to represent you. Is there an offer to resolve this case?
There is, Your Honor, an adjudication, credit time served.
She would like to accept and enter a plea of no contest.
All right, Ms. Thomas. I was handed a plea form. Do you have a chance to go over this plea form with your attorney?
Yes.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights listed on this plea form?
Yes.
You under the influence of any drugs, alcohol, or medications affecting your ability to understand what's happening here today?
No, sir.
Do you understand that if you were on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yes, sir.
And do you understand that if you are not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, sir.
And if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment. Do you understand that?
Yes.
All right, we'll accept the no contest plea, adjudicate you guilty, sentence you to, what, 2 days?
One.
1 day in the Orange County Jail with credit for the 1 day that you've already served plus court costs. Give you 1 year from the date of the release to settle up the court costs if you're not on a payment plan making regular payments. And there's still a balance after a year, the clerk of court's going to administratively suspend your driver's license, okay? All right, thank you. All right, sir, what's your name?
My name is Lionel Wilkerson.
All right, Mr. Wilkerson. You're here on, your arrest on 1 count of prostitution, first violation. You're also out on bond on aggravated battery with a weapon.
Excuse me, sir.
Hold on 1 second. I'm going to appoint the public defender to represent you, okay? Anything, today's just your first appearance, okay? Anything, understand that anything you say can and will be used against you, so I'm going to appoint the public defender to represent you.
Yes, sir.
I'm just, what we're doing here today is just going over what you've been charged with and determining some conditions of release. So I've read the arrest affidavit for the prostitution. I do find there's probable cause. State, do you have a position on the case that he was out on bond, given the nature of the new law?
I'm gonna double check, see if it's filed.
It hasn't been. He was arrested on, it looks like July 8th.
July 8th.
The date no information has been filed. So defense would ask that you take no action on the out on bond, Your Honor.
What are those bonds currently? Same amount, just,
What I see is 5,000 and 2,500,
okay.
if that's correct.
All right, Mr. Wilkerson, I'm gonna set bond on the prostitution offense, $500. Okay? I'm gonna take no action on the cases that you're out on bond on. Understanding, and, you know, I'm not looking for thanks or anything like that, but if it had been a different judge sitting up here, it might have been a different result, okay? When you're out on bond and you commit new law violations, even like as small as the one that you came in here on, you don't have a right to a bond anymore, okay? So the court would be within its discretion to hold you no bond. So I can't give you legal advice, just the life advice I would give you is while you're out on these bonds, try to keep your nose clean, all right?
Thank you, sir.
Because you get picked up again, there's no guarantee you're getting out of here, okay?
Thank you, sir.
All right, you're welcome.
Erica Wilson is mental health.
And I will waive, Your Honor. I would just ask that you stay the bond or mental health pretrial release if she qualifies. She has a history of mental health issues, Your Honor.
All right, that's Ms. Wilkerson,
Yes, Your Honor. Wilson, sorry.
or Wilson.
Wilson Ayers.
We just said Wilkerson. All right, does she qualify for mental health PTR
You can have her screened, yeah,
screen?
at my department.
Okay, so we'll just stay the bond and then have her screened, or do we, is that typically what we?
Order mental health PTR or the bond.
Okay, so we'll order mental health PTR, or we'll maintain the bond, we'll set bond at 250 if she doesn't qualify.
Thank you, Your Honor.
All right, so, ma'am, what's your name?
Amber Rose Woolery.
All right, Ms. Woolery. You're here on one count of prostitution. I've read the affidavit. I do find there's probable cause. Court's inclined to stay the bond at $500. Any objection from the state?
No, Your Honor.
All right, do you have an attorney, or you want to see if or you want me to appoint the
Is there
public
any way I
defender?
can get pretrial release?
I don't believe, she didn't qualify for pretrial release, right? You don't qualify for pretrial release, there's a screening process that goes into that. You didn't qualify, so I'm gonna set the bond at $500. I'm gonna appoint the public defender's office to represent you. If you have an issue with bonding out, hopefully your attorneys can take care of that for you, okay? All right. All right. Ma'am, what's your name?
Demetria Bravo.
All right, Ms. Bravo, you came in here on a warrant for failure to appear on account of possession of drug paraphernalia. The bond amount on that was $2,000. I'm gonna stay the bond at, well, it's a 2015 case. I'm gonna stay the bond at $2,000.
Your Honor, I'm going to announce a null pros.
All right, state just dropped the charges against you, okay? So the state just dropped the charges against you, so you're gonna be released as it relates to this charge today, okay?
I promise you I won't come back to the.
Don't make those promises. I don't want to, I don't,
So
but I hope you don't, but don't promise me that.
I'll stay in Pasco County.
Okay, well, then you can make that promise. All right, that was Ms. Bravos. All right, sir, what's your name?
Joseph Esoff, Your Honor, how you doing, sir?
I'm doing all right. All right, Mr. Esoff. All right, you're here, you came in on a warrant. I believe I signed this warrant.
Yes, sir. They gave me a plea, sir, and they sent me the fingerprints to plea out on the criminal mischief, or take the battery and drop the criminal mischief, but I didn't get it in the mail. And I tried calling the public defender, the 7th one on my case, and I lost my ID to get up here to court. And this has been going on for 2 years, sir. I work in Palm Beach. I'm trying to see if I can still get that plea. And
You do have the Office of the Public Defender appointed to represent you, I believe, in this case, correct?
yeah, but my
Yes, Your
public.
Honor. However, I do not believe the state is making an offer today. He has to resolve the case in the trial division.
All right, so you came in with a bond of, it's for failure to appear. The public defender's office is a big office. If you call there, they should get the information to who needs it, okay? I remember this case when your case got called for whatever you were supposed to appear for.
Yes, sir.
The public defender's office indicated they had no contact with you, okay? And that's, like I said, it's a big office, so that's why the failure to appear was issued. I'm gonna modify the bond.
I won't be able to bond, sir, because my check hasn't got here till the 3rd, but I would like to ask this, Your Honor. Can you see if you can make an offer with the state right now? I got time on it.
Because it's a battery, we're not gonna resolve it here today because we gotta have contact with the victim, okay? So there's not gonna be an offer to resolve it here today. It's not like a trespass, possession of drugs, something like that, when there's another person involved. The state and the court wants to hear from that person before we make an offer, okay?
I do want you to know, Your Honor, that my public defenders cannot even pull cameras from the Circle K where this happened.
Okay,
This has been an ongoing issue. That's why they've been running through plenty of public defenders.
all right.
Matter of fact, I'm the one who got hit in the face. I
Well-
didn't even strike back.
I
I'll
would not-
leave it at that.
It's all right, listen, anything you say can and will be used against you, so just please, you have attorneys, that's what they're for, but in order to resolve the case,
Yes,
you gotta
sir.
show up to court. So,
Well, I'm here now. You can keep me in custody because I live in Palm Beach.
all right, well, then we'll just keep the bonds with what they're at, and, your next court date,
Would be when?
it'll be set, it'll probably be in the next few weeks, couple weeks, okay?
Weeks. All right.
All right? Okay,
And Your Honor, I will waive the appearance.
all right, we'll stay the bond on that case. Marisol Garcia? Yeah. She bonded? All right. Next, we have Timothy Hitchcock. All right. We'll appoint the public defender to represent Mr. Hitchcock.
I can't see,
The court was inclined to revoke the ROR. He doesn't qualify for pretrial release, so does he?
Oh, yeah.
do we know why he was ROR, Your Honor? I haven't, my system is completely down.
It just says he was ROR, it was another trespass,
Hold on.
previous trespass. And this is
It's been.
this is a open container.
It has been filed, the Allen bond. It was an ROR.
It has not.
So he refused? That was the,
Let's see.
that's why he wasn't brought up?
33-day ROR.
He's not mental health or any, he just,
I'm just trying to see why they ROR. Did they have conflict? It's harder for me to find out. Your Honor,
He was just, out on bond, the 5501, he was just arrested August 15th. He was released ROR 816, I'm assuming,
33 day.
no, it was 1 day.
Oh, it was 1 day? Oh, so probably at IA's.
It was at IA, he was released ROR.
Can you tell him that trespass was at the Target, the one he was ROR'd on?
It was a Walgreens on Colonial.
don't know if
So
was-
same block.
he has a 20-plus Baker Act, Your Honor.
It has no objection to taking no action on the out on bond and just staying the 250 on the,
Yeah, that's what, we'll take no action on the one he's ROR'd on and just, stay the $250 bond on the open container.
Thank you.
Took no action on that one and then stay the 250.
Okay. Thank you. 'Cause I
Ray
don't have
Lamar?
access to my system. And I will, waive the appearance, Your Honor. I believe he has also, he's been found incompetent to proceed.
Well, I've reviewed the arrest affidavit. The way it's written, I'm not gonna find probable cause because 4306K says that the vehicles must be stopped in abeyance of a traffic control device, and there's no allegations in the arrest affidavit that the vehicles he was approaching were stopped in abeyance of a traffic control device, so we'll find no PC and RORM on that.
Thank you, Your Honor.
And no action on the out of bond?
Is he out on bond too?
Yes,
Yeah,
same
we'll
thing.
we'll take no action on,
He's been deemed incompetent, so we couldn't.
yeah, we'll take no action. All right. Chanel Miller, bonded. Mr. Dyson? All right. One second. All right, Mr. Dyson, you're here on count of driving while license suspended with knowledge, no motor vehicle registration, no motorcycle license. You were out on bond on a count of no valid driver's license. I'm appointing the public defender's office to represent you. I've reviewed the charging affidavit, find there's probable cause on each count. State, do you have a position on the no valid that he was out on bond on?
Your Honor, state will leave that within your discretion, given that he was out on bond for a driving offense and picked up a new driving offense.
All right. All right, we're gonna revoke the bond on the one that he was out on bond on and issue a new bond of $2,500. On the new offense, driving while license suspended or revoked, count one would be a $2,500 bond and $250 bonds on counts 2 and 3. Moral of the story is you gotta quit driving. Like I told a gentleman or young lady who was in here before you, I don't know how they know, but when your license is suspended, they know that your license is suspended. And every time you drive, they will pull you over. And every time you come in here without a valid driver's license, the penalties just go. So either fix a driver's license or quit driving, or else it's, it just keeps snowballing, okay? All right, good luck to you, sir.
Tyler Ingalls, bonded.
Ingalls bonded? Sure. Sir, what's your name?
Daniel Metallic.
All right. One second. All right. You're here on one count of driving while, or DUI, driving under the influence. I reviewed the arrest affidavit, do find probable cause. Set bond in that case of $500. You're also on probation, I believe out of Polk County, for possession, and it was felony probation. We're gonna stay the bond at no bond on that one. So you're gonna be held on that violation of probation, Polk County, no bond until that gets resolved one way or another, okay? All right, thank you. All right, sir, what's your name?
Ernest Petway.
All right, Mr. Petway, you have two cases. One is a failure to appear for driving while license suspended with knowledge. The other is a possession of a DL with altered date of birth. On count one, I'm going to appoint the public defender to represent you. On the failure to appear, the bond was at $500. I'm going to stay that bond at $500, okay? On the possession of an ID with altered date of birth, the court's reviewed the probable cause affidavit. I don't know if there's sufficient facts to find probable cause at this point. There's a kind of a conclusory statement that it contained the incorrect information, date of birth, name, address, driver's license number, but it doesn't say what the date of birth was. So,
It would ask for a 24-hour reset.
all right, we'll do a 24-hour reset in order to get the probable cause on count two. In the meantime, we're gonna set bond on that one at $100, okay? Mr. who? Yes. We had Gerald Pierre though too. I haven't, refusal? Okay. So we'll appoint the public defender.
I will waive, Your Honor.
All right.
What are you gonna do? You gonna stay the bond?
Oh, he was trying, yeah, we'll take no action in the one he was out on bond on and stay the bond.
For who?
Pierre, Gerald Pierre.
Okay. Taking no action on all his auto bonds?
How many did he have? Hold on, let me see. Sorry. Thank you.
3.
Oh, yeah, never mind. We'll take no action on the trespass. We'll revoke the bonds, issue a no bond on the delivery of cocaine. 20.
You can plea for him, right?
2022 CF
No?
4567 AO
You can give me an offer for him?
and 4566 AO.
Your Honor. You have it?
It's an adjudication.
I'm sorry. My system's down. Why wasn't he able to appear? He refused? Oh, okay.
So he was out on bond delivery of cocaine within 1,000 feet of a child care facility and delivery of fentanyl in two separate case numbers. In both the drug cases, we're gonna revoke the bond, and revoke the ROR on the delivery of cocaine, delivery of fentanyl. Set those at no bond. Take no action on the trespass in 2022 MM 3213 AO. And then stay the bond in the case he was here on initial appearance of 500.
No, when he's revoked. I don't know what you want. I've seen it.
Just 22, 4, 5, 6, 6.
All right, this is Mr. Borg. All right,
6, 6.
1 second.
Thank you.
Yes.
I put it in.
The attorney on. Okay.
No equity problems.
All right, Mr. Borg, you are here on 2 counts. 1, possession of controlled substance without a prescription, possession of drug equipment, and/or use. I've reviewed the financial affidavit. Find there is probable cause. State, do you have a position as to bond?
Your Honor, state would just ask that you stay what's currently set.
Given the facts alleged in the financial affidavit, including a individual who appeared to be overdosing, court's gonna set bond on count 1 at $5,000 and $250 on count 2.
And you did appoint us, correct, Your Honor?
Yes, and we'll appoint the public defender to represent you, okay?
My name is Brian Barnash.
All right, Mr. Barnash, give me 1 second. Yes. All right, Mr. Barnash, you're here on 1 count of driving while license permanently revoked. It's a bond of, well, it came in on a bond of $5,000. I've reviewed the arrest affidavit and understand, what's going on, but do find that there's probable cause, you operated a motor vehicle without a valid driver's license. You're also out on probation out of Lake County. So I'm gonna stay the bond in this case at $5,000. I'm gonna maintain the no bond, status out of Lake County until that gets resolved one way or another, okay? Yeah, I'm gonna appoint the public defender to represent you. Be careful, anything you say can and will be used against you. Today's just about setting conditions of release.
You'll be seen here for the probation. It doesn't matter. Set it at. We're gonna have to call and speak with the attorney to see if
Oh, yeah. All right. Video conference.
Welcome to an Econo meeting. You are entering the meeting now.
All right, Mr. Mason? Can you hear us? Mr. Mason, can you hear us okay? If you're talking.
Yes, I can hear you. Can you hear me?
Yeah, I got you. You here on,
Okay.
Shamar Caprice?
Yes, Your Honor.
All right. Let me take a look real quick. Nope. I'll let Calvin bond it. All right, Mr. Caprice, he was out on bond and carrying a concealed firearm, possession of cannabis with intent, was picked up on, new possession of cannabis with intent, possession of cannabis over 20 grams, possession of drug paraphernalia, possession of THC. Counsel, do you have a position on, or want to be heard on any of that?
Yeah. The cases that previously you just stated, he's actually not out on bond on those anymore. They're both referred to pretrial diversion. So this is probably going to affect him that he could get thrown out of diversion, which may not, because Orange County doesn't tend to prosecute the weed cases. But he's on diversion, not on bond. So there shouldn't be any bonds to violate.
Okay.
Well, it looks
And I
like
actually just got his pretrial diversion contract in the last one. I think it was May 13th.
Okay.
in your honor, it still looks like he's on pretrial release for 21 CF 9245 because we received a revocation form from his pretrial officer.
Did you hear that, counsel?
I do hear that, but if it was from which one? 21.
9245, that's possession of cannabis with intent.
That's 9245. Trying to find the, that one should be, I think that one went into diversion as well, did it not?
We can look.
Your Honor,
I'm sorry, I'm trying to pull it up right now.
or he would still be under the jurisdiction of the court. And even though he was in the pretrial diversion program, that is a state-run program, not by this court, he's still under the jurisdiction of the court to not commit any new law violations when he has other cases open and pending. And a case in pretrial diversion that has not been dropped is still open and pending. And they are substantially similar, exactly the exact same charges. So we just ask that you take that into account when setting his bond on the new law and consider revoking his out on bond.
So I understood, but generally the course of practice, I'm trying to pull up the docket on this one right now. Generally speaking, the course of practice is a large portion of judges was once you go into diversion, they release the bond. So if there's been a monetary bond, you'd be released. I guess the issue here is since it's PTR, maybe they didn't state to release it. Is that not, I mean, officer, I bet, is that not your experience, a large number once they're on the PTD that they're released from supervision?
I don't know. I mean, I think they're technically still out on bond when they're in diversion because the case just gets abated. You know, there's really no action taken on the bond or the pretrial release, or unless there is an order of the court to modify that. My understanding is just going to diversion, the conditions of release remain and the conditions of bond remain in place.
I'm just trying to, I'm really trying to, if the court's moving fast, and then I don't need the time, but I was just looking to try to pull this up.
No, that's okay. Here's what we're gonna do, and if you wanna, you know, bring this to someone's attention.
I have an argument to make outside of that. If you're just saying forget it, I do have an argument. If you're saying that we're gonna accept that he's still on that, I have one argument to make before we move on.
Yeah, go ahead.
Okay. Then my argument would be in this case is that even if he was on former pretrial release, I would ask the court to take in consideration that the pretrial version, or at least in the Orange County, is the arrest for cannabis is discretionary on the officers, and two, Orange County tends not to prosecute the cannabis cases. Most of these end in usually a pretrial diversion that does a 4-hour class, then a 4-hour online class. His case, the reason we did the full diversion is he had picked up 2 cases, so we divided it into 1 case and allowed him to do it that way. Otherwise, the cannabis case would already be gone. So I'd ask, just because it's cannabis, is if we could give him a bond, and then if the state wants to do a motion to revoke on cannabis, that they could go ahead and do that. But I don't believe he's a danger to society, and I don't believe that he's going to fail to appear.
Okay. All right, just give me a second to think about it. I mean, the other case he was in diversion on was carrying a concealed firearm too. So that gives just the court a little pause on, you know, I want to make sure we do the right thing.
Understood. And just for the benefit of the court on that, he was legally allowed to have the gun. It was just that it was concealed that made it a crime.
And Your Honor, in regards to defense's argument that he's not a danger to the community, I believe when Mr. Caprice was speaking to law enforcement, he stated that he had a marijuana card and he believed he could smoke in the vehicle with it. So state's concerned regarding, and the law enforcement officer, when he approached the vehicle, stated that the smell of cannabis grew even stronger. And that was one of the reasons why he pulled him over, in addition to speeding. The state's concerned regarding Mr. Caprice potentially also smoking within the vehicle and operating the vehicle, in which he would be a danger to the community.
In regard to that, I would say that the officer didn't conduct a field sobriety exercise. I'm confident that since he arrested him for marijuana, he's definitely probably shook all the leaves.
Here's what we're going to do. We're going to take no action on the ones that he was out on. if he was in pretrial diversion, we're not gonna revoke those. He's gonna get a bond. I'm gonna set bond. I did find probable cause of possession of cannabis with intent to deliver. Given that he was on diversion for the exact same offense, we're gonna set bond in that case of $25,000.
Perfect.
The possession of cannabis more than 20 grams, I'm fine, there's not probable cause. He just says 20 grams. I don't know if he visually estimated that, or in the arrest affidavit, he just says it was over 20 grams. There's no exact way. I'm gonna find no probable cause as to that. You have 24 hours, state to,
State's not requesting 24, Your Honor.
okay. So no probable cause for ROR as to the possession over 20. And then the, counts 3 and 4, the court did find probable cause. We'll set bonds of $250 on count 3 and $250 on count 4.
Thank you, Your Honor. That was very reasonable. And then
Hold on,
also,
there's gonna be a condition, sorry, that you do not possess a firearm. If you do, or any weapons. If you do have any weapons or firearms in your possession, you need to turn those over to law enforcement within 24 hours, okay? Anything else, Mr. Mason?
no, my comment still remains the same. That was very reasonable. If this case is concluded, I want to make one more comment when you're done.
Yeah, I think we're good.
I was gonna say, as to yesterday's case, I appreciate your discretion there too in resetting that case.
Oh, no problem. I understand life happens, so I hope everything's okay with, your father.
All right, I appreciate it. Thank you very much, Your Honor.
Yeah. You're welcome. We'll see you later.
All right, Jim.
All right. Okay, sorry. Original bond would be, right? This is on. Okay, thank you.
You are the only participant.
All right, sir, what's your name?
Robert Cooks.
All right, Mr. Cooks. You came in, it was consolidated, so the active case number is 2021 CF 6206 FO. It was a different case number, AO. The RICO did get consolidated where he's co-defendant F. This came in on a warrant. Count 1, engage in a pattern of racketeering activity. 2, 1 count of racketeering. The bonds on those warrants, $500,000 on count 1, $250,000 on count 2. Court's going to stay those bonds. I will appoint the public defender's office to represent you. There's also a failure to appear. There also was a warrant signed by a different judge on possession of firearm by a convicted felon in a separate case. That came in no bond. We're going to stay that bond in accordance with the warrant signed by the other judge. We'll appoint the public defender's office to represent you in that case if they haven't been appointed already. If you have your own attorney, that's fine too. Just need to let the public defender's office know, okay? All right, thank you. We just, so he came, there was one case which was an AO. And it was those RICO cases. And when those RICO cases, they got so many co-defendants, they consolidated it into the FO. So it's consolidated in 6206 FO. All right, sir, what's your name?
Jerry Cummings.
All right, Mr. Cummings. You're here on a failure to appear for a case management conference on August 25th, 2022. The bond amount listed in the warrant is no bond. We're going to stay the bond amounts that came in on the warrant, so you're going to be held no bond until further order of the court, okay? All right, good luck to you. We'll appoint the public defender's office to represent you if they haven't already been appointed.
Yeah, I'm sorry. For the previous defendant Cooks, did you call all 3 cases?
The AO was consolidated into FO. So when I pulled it up on Odyssey, there's one case number that ends in AO with the same racketeering counts, the 2 counts. And that got consolidated into, what did my post-it say? Sorry.
732.
It got consolidated into 2021 CF 626 FO. So there should be, the only active case should be the 626FO.
They served both of the cases.
Yeah, so we're just, the bonds are only on,
Their bonds on both cases in our system. Because that's how they were served from the arresting officer.
yeah,
So do you want to ROR one of the case? The case that was consolidated into the other one?
yeah, so on the AO case, we can ROR. I know, it was confusing me as I was looking at it too, but that's what, these RICO cases, they, they get like co-defendants A through J, because it's like a racketeering. There's a lot of co-defendants, so I think when he first got arrested, he was AO, and then when they consolidated all the co-defendants together, same charges, same conduct, just, yeah. And then we did take care of the firearm case, right? We no bond on that one. Okay, thanks. All right, so what's your name?
Willie Farah,
Refused? All right, we'll appoint the public defender. We'll stay the bond in that case. That was a warrant too. So.
Here's bonds.
It's
Really?
fine, it was a capious.
It's a set.
Huh?
It's a set the bond?
What is?
No, it's a
Conditions?
Set it nice. It was
There's
the,
also conditions on the warrant that you have no contact directly with victim, co-defendant, or witnesses, and do not return to the scene of the offense.
But isn't he entitled to a bond?
I want a capious. Your Honor, I believe there's potentially some confusion.
I can't see it, that's why.
It's my understanding on the 22 CF 10069.
Yeah.
It is a capious, which is why it said at no bond. Is that what Your Honor sees?
Yeah, it's a capious for failure, it's,
For failure to appear.
It's a failure to appear? It's a new law?
it's a probable cause order.
He's
And
entitled.
so he might be entitled to a bond. It says capious.
Yes, a capious.
Doesn't mean he's not entitled to a bond.
But if it's a violation of a court order, aggravated stalking after court prohibition, is he entitled to a bond on that?
Yeah.
So I believe he has private counsel on it.
Let's see. Looks like Judge Roche issued an order directing the clerk to issue a capias. Without, ordered no bond.
I thought usually they come in as no bond.
Right.
And usually they set bond, that's why I was a little confused about the.
The way it's charged, aggravated stalking after a court prohibition, I don't know if you're entitled to a bond if you violated a court order. It's kind of like a condition of.
You say he has private?
He violated a no contact order in.
Yeah, he has private counsel anyway, Your Honor.
He does, okay.
Yes.
All right, we'll stay the bond at none. The violation of no contact order without being aware of anything else, that's akin to violating a condition of release, so. I don't know if he's entitled to bond, but we'll stay it at none. That's what Judge Roche put in there. Who's the private attorney?
Blankner.
Blankner?
When did he file an NOA, or we're just not seeing it?
I have it in my system as him. One second. He just filed a motion for speedy, or demand for speedy 8-6. I don't see an
Are we on
NOA.
2022 CF 10069 AO?
Yes, Your Honor.
I don't see any of
Yeah, I have that demand for speedy on 8-6 filed by Mr. Blankner. Would Your Honor like to see it? It's weird that it would show up in Odyssey, but
I see him I see Mr. Blankner was his attorney in 2021 CF 1365 AO. But I just didn't see him in the.
yeah.
That's okay. That other case is, so, yeah, I'm gonna hold him no bond. That other case is still pending. I think that's where the no contact order was, and it's, the counts in that case, 2021 CF 1365 AO, lewd and lascivious, molestation, sexual activity with 16 or 17-year-old child. I'm not sure he's entitled on a bond for violating that no contact order. So yeah, we'll just stay the bond, and if you're seeing Mr. Blankner's filed a notice of appearance in that case, I'm sure he'll file the appropriate motions.
I don't see an NOA. I see a demand for speedy.
Well, he represents him in the other case, so I'm sure he's aware of it. And I'm sure he'll file the appropriate motions.
And I see that we were sending them
Does he refuse?
notice to take judicial notice and statement for particulars. We were sending them all that earlier this year. So.
Reset it. Yeah, well, let's reset it to, sorry.
Tomorrow?
So we can all get on the same page. Let's reset this to, reset it to next week? Or just tomorrow? All right, we'll reset it to tomorrow. In the meantime, if you want to send Mr. Blankner an email, or, I don't know. Maybe, yeah, hopefully word can get to him. All right, sir, what's your name? What's your name, sir?
My name is Afnan Gustav.
Yeah. Afner Gustave?
Yes.
Okay. All right. You're here on 3 counts, 1 count of burglary of a dwelling, 1 count battery, 1 count resisting an officer without violence. I've reviewed the arrest affidavit, find there's probable cause. Court's inclined to stay the bonds at $5,000 on count 1, 100 on count 2, 100 on count 3. I'll appoint the Office of the Public Defender to represent you. State any objection to those bonds?
No, Your Honor. State would just ask for no return and no contact.
All right, as a condition of your bonds, I'm going to order that you do not return to the address where this is alleged to have occurred and have no contact with the alleged victim. No contact means no contact, not through any apps, messaging systems, anything like that. So you do have bond on this case. A condition, if you do bond out, even if you don't bond out, conditions of those bonds, you have no contact with the alleged victim and you don't return to the residence where this is alleged to have occurred, okay? All right. You have a good day. All right, sir, what's your name? All right, Mr. Hayward, you're here on 3 counts. 1 count possession of cocaine with intent to deliver, trafficking amounts of methamphetamines, possession of cannabis less than 20 grams. I reviewed the arrest affidavit. I do find probable cause. I'll appoint the public defender's office to represent you. State, do you have a position on a reasonable bond on these?
Your Honor, Steve just asked that you stay count 2 and has no objection to you treating 1 and 3 as subsidiaries. I believe that is what the bond schedule has.
Right.
And I believe Mr. Hayward does have previous drug-related offenses and violent-related offenses.
All right. On count 2, which was a $100,000 bond, I'm gonna set bond at $75,000. Counts 1, set bond at $250. Count 3, I'll set bond at $250. So that you have bonds in this case, on these cases. You have an attorney that I'm appointing the office of the public defender. The total amount of bond in your case is $75,500, okay? All right. Have to step outside. Thank you. If I write on those, is that bad too? I don't mean, I can write on those? Okay. I'd rather just write while I'm talking. Yeah. All right, sir, what's your name?
It's John.
John Hedridge?
My last name is John.
Okay. First name Hedridge? Okay. All right, you're here on 1 count of burglary of a structure, 2 counts of criminal mischief. State, I'm kind of on the fence on the offense to be committed within the structure. Do you have any probable cause? What's the offense that was to be committed within the structure?
It was the criminal mischief to breaking everything within the bathroom, Your Honor.
Okay.
I believe there's one of these charges are criminal mischief for
One of them's the car
one of the
and one of them's
vehicles.
the bathroom? Okay.
I believe so, but I believe the crime committed therein would be the criminal mischief, Your Honor. Damaging the bathroom, the sink, I believe.
All right. All right, court does find probable cause. We'll stay the bonds at $3,500 on count 1. We'll do $100 on count 2 and $100 on count 3. I'll appoint the public defender's office to represent you. So stay in contact with them, but that you do have bonds on these cases, okay?
Your Honor, state would ask for a no return to Earl's.
And do not return to the Earls where this is all alleged to have happened, okay? That's gonna be a condition. If you do bond out, you can't go back there, all right? All right, sir, what's your name?
Holloman.
All right, Mr. Holloman. All right, Mr. Holloman, you were, I got the wrong one. There we go. What happened to Henningham? Shoot.
You have an inmate number, jail number?
It's in the middle. Where is it? Okay, 220205454. Selena Henningham.
She bonded, Your Honor.
She bonded? Okay. All right, sir. Mr. Holloman, correct?
Yes, sir.
All right, you're here on a failure to appear, possession of MDMA, 1 second. Another count of possession of MDMA. One of the counts of possession of MDMA and the failure to appear possession of controlled substance, both of those have warrants. I'm gonna stay the bond on the first, the failure to appear warrant of $2,000. On the other warrant, in 2022 CF 10127AO, I'm gonna stay that bond at $1,000. And then in 2022 CF 10112AO, reduce that bond to $500. So about $3,500 total in bond, okay?
Sir.
All right, also, condition of your release that you not possess any illegal drugs, okay?
Sir.
You're welcome. All right, sir, what's your name?
Frederick Howard, sir.
We don't care about.
All right, Mr. Howard, you are here on 2 counts. 1 count possession of fentanyl, 2nd count possession of drug paraphernalia. You were also ROR'd on a separate case for possession of controlled substances. An information been filed on the CF case he was out on bond on?
Yes, the 5251, yes, that information was filed.
All right. All right, so in case 2022 CF 5251AO, gonna revoke your bond, set that at none. And on the new case, you came in here today on possession of fentanyl, stay that bond at $1,500. Possession of drug paraphernalia at $500. All right. And I'll appoint the office of the public defender to represent you.
You did it before, right?
Wendy Jackson bonded.
All right. All right, sir, what's your name?
Benjamin Underbow, sir.
All right, sir, you were arrested on a warrant. Count 1, the bond was set at $50,000. Count 2, $2,500. Count 3, $4,000 for a total bond of $56,500. It says it's a failure to appear. It should not have been a failure to appear. It's a probable cause warrant that was issued by the judge. We're going to stay the bonds that are in that warrant. Appoint the public defender's office to represent you. So you do have bonds on these cases that the warrant came in on, so you have to step outside, okay? All right, sir, what's your name?
Earl Miller.
All right, Mr. Miller, you came in on a warrant for aggravated child abuse. The warrant came in no bond. I'm appointing the public defender's office to represent you. Stay you stipulate he's entitled to a reasonable bond on this?
Yes, Your Honor, it is an F1. However, it is not a PPL, so he is entitled to a bond. However, state does have some argument as to the amount.
Yeah, let's hear it.
And according to the warrant, I believe the child sustained 8 fractured ribs, a laceration to the spleen, a laceration to the liver, laceration to the pancreas, a bilateral pneumothorax, and spinal bruising to the L3 and L5 vertebrae. He was the sole person in custody of the child when these injuries occurred. Mr. Miller also has a fairly lengthy criminal history, mostly of drug offenses. However, he does have a conviction also for child neglect. State did look up that case. It is out of county, where he allegedly, I believe he pled to it, was buying narcotics with a 2-year-old child in the vehicle. He also has several other offenses with children, including just like seatbelt violations with a child in the vehicle.
You know if this child in this particular instance is his child?
I do not believe it is. I believe the child was his girlfriend's child. I believe they've been dating for around 6 months, living together for about 3 months. And it's alleged that the mother, his girlfriend, went to work, and he was in charge of the child from, I believe, 4 a.m. to about 7:30 a.m. when another woman came to pick up the child to take to daycare. That's my understanding of the reading. So he had about 3.5 hours with the child. But given the injuries sustained by the child, that he does have a prior conviction for child neglect, which involved drugs and a very significant, lengthy criminal history with drugs. And that it is an F1.
All right. Court's inclined, the court agrees that he is entitled to bond. Bond's gonna be set at $500,000. Special condition, you have no contact with any children. Do you have, I'm gonna ask your attorney. You can talk, I don't want you to say anything. I want you to talk to your attorney. Does he have kids of his own?
He has 3.
Do they currently live with him?
They're with their mother, Your Honor.
All right.
I believe there were other children listed in the affidavit that were taken by TCF. I'm not sure if they were his or the girlfriend's children. I'm not sure.
They were his girlfriend, Your Honor.
I'm gonna order that no physical contact with any minor children, including your own children. If you want to communicate with them, your own children over the phone or via you can do that, but no physical contact with any minor children. That you comply with any conditions imposed by DCF. If DCF imposes any conditions, you comply with those. You consume no illegal drugs and no alcohol. You possess no weapons, including knives, firearms, ammunition. To the extent you have any weapons in your possession, you surrender those to the appropriate law enforcement, to a law enforcement agency within 24 hours upon your release, should you be released. Counsel, you had something?
No, Your Honor, I just wanted to tell him.
Okay. All right, thank you. Sir, what's your name?
David Manuel Marino.
All right, Mr. Moreno, you're here on one count of possession of a controlled substance.
I didn't even know it was drugs.
Hold on.
Jesus, stop.
Anything you say can and will be used against you. Everything's being recorded, so I'm going to appoint the public defender's office to represent you.
Okay.
I've reviewed the probable cause affidavit. I find that there is probable cause. There's also a traffic violation, drawn while license suspended with knowledge. Find there's probable cause on that as well. Appoint the public defender's office to represent you. I'm gonna stay the bonds, $2,500 on the possession of controlled substance, and on the subsidiary offense of driving while license suspended, we'll set that bond at $100, okay? All right,
Thank you.
thank you. All right, ma'am, what's your name?
Melanie Nicholson.
All right, Miss Nicholson. You're here on one count of grand theft of motor vehicle, one count of possession of drug paraphernalia, one count of possession of Xanax, count of possession of cannabis, less than 20 grams. One count of possession of cocaine. Reviewed the arrest affidavit, find there is probable cause. State any objection to staying the bonds?
No objection.
All right, so I'm gonna stay the bonds as they came in. Count one, the grand theft, the bond's gonna be set at $1,000. Count two, possession of drug paraphernalia, $100. Count three, possession of Xanax, $150. Count four, possession of cannabis, less than 20 grams, $100. And count five, possession of cocaine, $150. I'll appoint, if I hadn't already, appoint the Office of the Public Defender to represent you. But those will be the bonds on your case, okay? All right, ma'am, what's your name? All right, Ms. Pettis, you're here. Two separate cases. In the first case, 2022 CF 10111AO, it's 4 counts. Count one, possession of firearm and commission of a felony. Count three, grand theft, 3rd degree. Is that with a firearm or of a firearm? It's with
Of a firearm, Your Honor.
What's that?
It's of a firearm.
Of a firearm. Possession of fentanyl, count three. Count four, possession of drug paraphernalia. Reviewed the arrest affidavit in that case, find there is probable cause. There is a second case, 2022 CF 10110AO. They are related. The count in that other case is 1 count grand theft 3rd degree. Find probable cause in that case as well. State any objection to staying the bonds in this case.
No, Your Honor.
All right, I'll appoint the Public Defender's Office to represent you. I'm going to stay the bonds as they are. So on count one in 10111AO, count one, bond's going to be set at $5,000. Count two, $150. Count three, $150. Count four, $100. And then in count one of 10110AO, that bond's going to remain at $1,000, okay? All right. And I've appointed the Public Defender's Office to represent you, so good luck to you.
Your Honor, I would, as to count the $5,000 bond, I don't know which count that was.
That was the commission of a felony with a firearm.
I would just ask that you consider reducing it to $3,000. My client can't afford it. I know she has the hold for Osceola, but once she posts the bond, then she can go deal with Osceola, but she can't post a $5,000 bond. Any objection to $3,000 or $3,500?
I state any objection, splitting difference at $4,000, and then that with the $1,000 on the other one, that's a total of $5,000 plus the subsidiaries. And if there's a hold in Osceola,
I'll send her.
I have no problems with $4,000 on the commission of a felony with a firearm.
That's fine, Your Honor.
All right, we'll set it at $4,000.
Rivera Jimenez bonded.
All right. Sir, what's your name? All All right, Mr. Shackelford, we were talking before, I don't know if you remember me, I was your public defender about 10 years ago, or 4 years ago, on this battery case that went to trial. I don't know if you remember that.
Oh, yeah, I remember.
Okay, so if you got no problem, I'm gonna appoint the public defender's office to represent you in this case, but I don't know if you, just knowing that, I just want to make that known. I don't have a problem proceeding forward with this hearing today, but, if you do, it's up to you. Okay. All right. All right, you came in on a warrant issued by Judge Epperson. Count 1, bond was set at $5,000, count 2 was $1,000, count 3 was $500, for a total bond on that warrant $6,500. However, the allegations in that warrant were occurred to have taken place while you're out on bond on two other cases. State, do you have any position as to the cases he was out on bond on?
Your Honor, state would ask that you revoke both of the out on bond cases. In 9028, it's a violent offense, false imprisonment, bat DV. The new law offense is also a violent offense, the ag bat with a deadly weapon, false imprisonment, and petty theft. It has not yet been filed on, however, it has not been 33 days yet. And in regards to the 22 CF 6285, that one has been filed on, and it also has a battery case, which is a violent offense, and he's here for another violent offense. So state would ask that you revoke both of his out on bonds and stay the bonds in the new law offense.
All right, appoint the office of the public defender to represent you.
Your Honor, you did check.
Do you have any argument?
I was just gonna ask, we did check the dates because my system is completely down. It did occur while he was out on bond, Your Honor.
I thought it might have, it looked like that way to me too. So I'm not going to revoke the bond on the grand theft third degree. I'm going to take no action on that one. And that is 2022 CF 6285AO. On the false imprisonment DV battery 2022 CF 009028AO. However, I'm going to revoke that bond. Said bond at none until further order of the court. Note in the state's argument that, these are substantially similar. That's the basis for the court's ruling on that. So the bonds on the new laws that came in on the warrant, those will remain unchanged. Okay?
Your Honor, state would just ask for no contact, no weapons,
Yeah.
no return.
It's written right in front of me. Mr. Shackelford, too, as a condition of your bonds and in each of your cases, that we're going to order you have no contact with any of the alleged victims, that you do not return to any of the residences, if there were residences where this was alleged to have occurred, and that you possess no weapons, including firearms, ammunition, okay? All right, good luck to you. All right, sir. What's your name?
This new one was August 2nd. Once we pull that little-
All right, Mr. Torres, you are here. Case number 2022 CF 10122AO. There's 7 counts. Possession of firearm ammo by a convicted felon. Possession of ammunition by a convicted felon. Possession of a firearm in commission of a felony. Possession of methamphetamine. Count 5, possession of cannabis. Count 6, possession of cocaine. Count 7, possession of drug paraphernalia. You're also ROR'd, which is out on a form of release on similar charges: possession of firearm by a convicted felon, possession of cocaine, possession of methamphetamine, possession of drug paraphernalia. That's in case 2022 CF 1040AO. State any position on bond in the case he was ROR'd?
That case has since been filed. We only filed the possession of firearm by convicted felon and possession of cocaine. And given that they are substantially similar, the state would ask that you revoke, Your Honor.
All right, I'm going to appoint the Office of the Public Defender to represent you. Given the nature of the offenses and the recency of the offenses and the similarity of the offenses, in 2022 CF 1040AO, we're going to revoke the ROR, set bond at none in that case until further order of the court. I'm appointing. Well, I've appointed the Office of the Public Defender to represent you. You've got two cases. One of them you were out on bond on when you picked up the new offense. Any defenses you have to that will be made at the appropriate time. All we're doing here today is setting appropriate conditions of release. Based on the allegations that are contained in both cases, the court finds it appropriate to revoke the ROR and set the bond at none in that case. We'll stay the bonds in the new case. You have an attorney that can file the appropriate motions to try to get you a bond, and that'll be up to a court at a different day. But just with what we have today, the court's revoking the RR, setting the bond at none. In the new case, staying the bonds, count 1, 5,000, count 2, 150, count 3, 150, count 4, 150, count 5, 100, count 6, 150, count 7, 100. The only advice I can give you, if you do get a bond in the new case and you're able to get out, don't put yourself in those situations. This is always going to happen. I'm telling you. Okay? All right. Good luck to you. Sign. We done?
We are.
Go on.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Morning, Madam Interpreter. We've got two cases for you this morning, okay?
Yes.
All right, Mr. Martinez is at the podium. He does have the headset on.
Sí, sí, le escucho.
There is contact, Your Honor.
Right. Sir, what is your name?
Gumaro Martínez. Gumaro Ángel Martínez.
Umaro Ángel Martínez.
Okay, Mr. Martinez, you're here are two criminal counts, one of driving under the influence and one of operating a motor vehicle without a valid driver's license. Court's reviewed the affidavit, does find there's probable cause. Set the bond in count 1 at $500 and count 2 of $100.
¿Está bien?
All right?
Sí.
You have a step outside.
It's fine, yes.
And have a step outside.
Sí, mientras salga de aquí para trabajar y como quieras, estamos para pagarlos.
I'm ready to pay and I would like to go to work.
You have a bond on this case. If you want to get out, you can bond out, or you can have someone else pay the bond for you, okay? You do have a bond on this case to get out of jail.
Me habían dicho que había venido una persona a depositar un bon, no sé, en el primer cargo. No sé cómo esté todo, si lo agarraron o tengo que hablar. Mis contactos no los saqué del teléfono, o sea, para tener yo comunicación ahorita afuera para hablar. No lo saqué.
They've told me someone came to post a bond on the first charge, but I don't know what happened, if he was able to, and then my contacts are in my phone and I was not able to take them out of the phone, so I won't be able to contact anyone.
Okay. I'm going to appoint the Office of the Public Defender to represent you. They're an attorney.
¿Sí está bien?
Yes, fine.
They can help you with that if you need help. But if someone's posted a bond for you,
Gracias.
And Your Honor, the reason he can't get out is because he's also being held here for a violation of probation, and it's set at no bond.
okay.
Sí, el DUI que no pagué, yo, bueno, me sacó de aquí la inmigración y
que ya me faltaban, todo tengo pagado, nada más son dos pagos que me faltaban para, según cumplir
Madam
la orden
Interpreter,
con mi
could you,
oficial que me habían nombrado.
Yes.
could you please advise the client that I did provide him with a form yesterday with the attorney's number circled? If he could call that number and speak with the attorney one-on-one to see about getting him a bond so that he can go back to work.
The VOP's in Orange County, Council?
Yes.
Sí, está bien.
Yes, it's fine.
Good luck, sir.
Gracias.
You do? Okay.
Thank you.
You don't need that. Okay, okay. All right, sir, what is your name?
Ramiro Cruz.
Ramiro Cruz.
All right, Mr. Cruz, you're here on one count of battery domestic violence. I will appoint the public defender to represent you. Is there anyone here for Mr. Cruz out there?
Sí.
All right. You do qualify for pretrial release. Court's going to order you on pretrial release. Order you have no contact with the alleged victim.
Okay. Gracias.
Order you surrender any weapons to the sheriff's office within 24 hours.
No tengo armas. No tengo nada.
I don't have weapons. I don't have anything.
And if you don't, that's fine. Just any that you do, if you did, you need to surrender those within 24 hours. If you don't have anything to surrender, that's fine.
Your Honor, could he have a one-time return with law enforcement to gather any of his belongings? I believe he lived in the household with the victim.
Okay, muchas gracias.
Yes.
Okay, thank you very much.
Yeah, you can return to the house or the residence one time with law enforcement. Don't go by yourself. You need to contact the sheriff's office or some other law enforcement agency to accompany you back to the residence so you can get any of your belongings. Other than that, you're not to return to the residence. You're to have no contact with the alleged victim. You understand?
Correcto, sí.
Your Honor,
Correct, yes.
I also believe DCF was contacted, so we asked for a permission to comply with DCF if any investigation is pending.
According to the affidavit, the Department of Children and Families was contacted. As a condition of your release, you are to comply with any conditions imposed by the Department of Children and Families, should they impose any. You understand?
Sí.
Yes.
Okay. Anything further?
No, Your Honor.
All right, good luck to you, sir.
Gracias.
Thank you.
All right, Madam Interpreter, I do believe that's all. Do you need those case numbers?
Yes, please.
All right. The first one was, let me find that for you. 2022 CT 4893 and 4894 AO. And the second one was 2022 MM 5939 AO.
Thank you, Your Honor.
All right, thank you, Madam Interpreter.
Thank you.
Okay. All right, sir, what's your name?
Mario Conti. Good morning, Your Honor. Ashley Barker on behalf of Mr. Conti.
It's Conti, okay. Let me find
The C. Yeah.
Yep, I got it. Okay, Mr. Conti, give me 1 second.
There is a victim present as well, Your Honor.
All right. All right, this is a warrant for violation of domestic violation of injunction of protection with 2 or more prior convictions. The warrant, which was signed by a different judge, came in with no bond. Counsel, is there any argument as to why bond should be imposed in this case?
Yes, Your Honor. If you review, and I think the state would agree, he has no prior failures to appear. His only prior arrest actually is for a violation of the injunction that was alleged by the victim in this case. But other than that, I mean, he works in the community, he lives here, he's got substantial ties to the community. I don't believe that he's a danger to the victim. The allegations in the warrant are basically she's alleging that he made some comments when they were exchanging the children. So again, I mean, we would just ask the court to exercise discretion and just set a bond within the bond schedule.
Does the state have an objection? I'm going to talk to the victim in a second, but does the state have an objection to setting a bond in this case?
No, Your Honor. I believe the allegations, as defense already stated, was, I believe he arguably yelled at her, something along the lines when they were exchanging the children. It wasn't another touching or anything, showing up at her house or anything like that, so it wasn't particularly egregious. So state has no objection to you setting a bond. However, I do not believe there is a bond on the bond schedule because it comes in at none due to the nature of the charge. But state would just bring your attention to, he is currently on probation for I believe it's a violation of a domestic injunction, with Ms. Conti being the victim. He had a prior 2019 non-arrest battery. It was declined to prosecute. Ms. Conti did not want to go forward. Same victim. A 2019 non-arrest felony extortion. She also did not go forward on that. It was the same victim. And then 2 prior 2019 violations of domestic injunctions. She also did not go forward on those charges, but however, it was the same victim. So this does seem to be an ongoing issue, at least since 2019, between the same defendant and the same victim. So state would just ask that you take that into account when setting bond for him.
All right, ma'am, and what is your name?
Stacy Conti.
All right, Ms. Conti, you have the, is there anything you would like to say to the court as the court considers whether or not to set bond in this case as it relates to this defendant?
I just want to be able to have physical and mental protection for myself and my kids. The initial injunction was in front of our children, and this last incident was in front of our children, and I'm worried for myself, but also for them. So I don't know if there's I don't know what you could recommend so that the children are not continuously involved, because there's also constant messages being sent through them that are very inappropriate and angry.
Here's what we're going to do. I'm not as familiar with this case as the judge that signed the warrant. I understand the allegations in this particular offense are not particularly that egregious. The judge who signed the warrant, who's more familiar with your case, ordered this to come in with no bond. I do note there's a history of violating this injunction. They're on probation for violating this injunction, prior injunctions. So this court is not comfortable setting a bond at this moment, just knowing that the history of violations, even though the court is aware and the state agrees that this particular violation was not particularly egregious, but this court's more comfortable with the judge who signed the warrant, who's more familiar with this case and the facts between these two parties, setting an appropriate bond, okay? So it doesn't mean you're never going to get a bond. It just means that, that these arguments probably need to be addressed at the judge who signed the warrant, okay?
Does it say who signed the warrant?
I can't tell the signature.
Because I would only argue, Judge, I think the judge who signed the warrant is basing, the no bond based on the affidavit for the arrest warrant. So I don't know if they're going to have any more information than Your Honor to make that decision.
Which judge is this assigned to? Do you know?
This is in.
Wooten?
Wooten.
That's not his signature, is it? You don't know? How old are the kids?
6, 7, and 9.
6, 7, and 9? And you two share custody? What's that arrangement like? Every other weekend, every Wednesday, or how's that work?
It's a little more
50-50?
complicated. It's every first and third weekend, every Monday for dinner, and then every Wednesday that he doesn't get them on the weekend.
Okay.
And again, Judge, I would just, if I can inquire, the victim, my understanding is that the meeting that was set up for them to exchange the children happened at a police station. My understanding is that Ms. Conti's now boyfriend was operating the vehicle, so he drove there.
That's not correct.
Okay. And if I can inquire, but my understanding is that he drove there. The comments were
That's not
directed
correct.
towards him.
It's okay. I'll ask you in a second what happened, but go ahead, counsel.
But again, that's my understanding, that the comments were directed towards the person who was operating the vehicle, who was Ms. Conti's boyfriend, and not directed at her. Again, I know the warrant's been signed, but again,
Do you have a copy of the affidavit?
I do, Judge.
Oh, here, I got it. Thank you. Give me 1 second. And ma'am, you were saying,
I was driving the vehicle. My boyfriend was never driving the vehicle.
but he was
And
there.
Mario asked to meet next to I was at the police station, and he said, "I'm not there. You have to come next door." And that was the American Legion.
Your Honor, if you are.
They share a parking lot though, right? The American Legion and the police station?
No.
No?
Your Honor, if you are inclined to set bonds on the violation, state would just ask that you find an on view for the violation of probation and set that at none, as you'd be entitled to none due to it being a violation of
Let
probation.
me see.
Is it possible too to get something like for our children in place too, where he can't send messages through them, or he can't?
Well, yeah. Let me review this real quick. All right, having reviewed the affidavit, the court's not willing to find an on-view VOP either, and I am going to set bond, given the nature of the allegations in the arrest affidavit. Bonds. I'm going to set bond at $15,000. And again, a condition of your release in this case is to have no hostile contact, and no contact with you or with the victim or with her boyfriend, other than it relates to exchanging of the children with any current agreement you have. And in those instances, it's no hostile contact, okay?
Can I ask, could there be some sort of like supervised visitation temporarily? So I don't have to see him at exchange, and this way, like, I can make sure that the kids are protected?
I can order that if you guys were already doing this at a police station, I can order that,
Judge,
yeah, go ahead.
sorry, I was going to say, we're okay with the court just saying, whatever the time sharing is right now, hold off, and we come in front of the judge who
Yeah.
actually has the case. That way, there's no, we don't want there to be any of that.
All right, so any time-sharing agreement, the kids are to remain in your custody until further order of the court. The court right now is going to suspend that time-sharing agreement per stipulation of counsel. And any modifications as to drop-offs and child exchanges can be addressed per further order of the court that's dealing with the custody situation, okay? But right now, the kids are to remain in your custody. Any time-sharing agreement that you guys have is to be suspended, okay?
And I guess, just again, I apologize, Judge, there's an order in the dissolution case, my understanding, Ms. Conti, about the exchange of the children. What I guess I was proposing is just regarding the criminal case, there being an order, I guess, from you saying no exchanges will come before, Judge, I think you said it was Wooten, to, I guess, readapt I'm trying to think of the right word, but basically accept the order from the dissolution case. We just temporarily, I think it's best if they just not meet up to.
I understand.
Until we get that. Or we can leave it as said. I was just.
We'll just leave it, that's all we're gonna do with that today, is just, we'll kind of suspend the time-sharing agreement that's in place until further order of the court, whether that gets reinstated or modified. That'll be an argument, but for right now, you guys don't have to exchange the kids per stipulation from his counsel, okay? So, any modifications you want to that agreement, whether it be supervised at a police station, whatever, in the company of law enforcement, whatever you want to do, you just gotta go ask the appropriate court, okay? And that may or may not happen. I'm not saying it will happen or won't happen, but that, to the extent it's gonna be modified, this court's not gonna do that here today. We're just gonna suspend it until a different court either reinstates what's currently in place or modifies that, okay? All right.
All right, thank you, Judge. That's all
Yep.
I have.
All right, thank you.
This person, because I don't have her.
Conti.
Her. They were both arrested. That's her, AKA. Okay, that's why I couldn't.
All right, sir, what's your name?
Nicholas Agostino, Your Honor.
All right, Mr. Agostino.
And Your Honor,
This is a
case has
VOP state, or?
No, Your Honor, it's just I believe it was a warrant case, and it has previously been filed.
I'm a little
confused.
confused about this case.
Yeah.
It appears he was
Arrested previously?
seen,
Charging affidavit?
So
and
what
I'm not sure why
He was previously
he was
arrested
already
on this
seen
case
on it.
in June as a charging affidavit, and now it's as a warrant. Same charges.
So what was the bond on the original affidavit?
There was no bond.
It was revoked.
So you've been in jail this whole time?
Well,
Hold on 1 second.
Just a moment.
June 2nd.
Yeah.
It wasn't, I believe he picked up, this is where I'm confused. It looks like he picked up the tampering with a witness, and then looks like the state may have filed a motion to revoke the bond on the battery charges for picking up the tampering, which was, it looks like it was granted. Yeah, I just not.
Okay, I see what happened.
Mhm.
So he was in here on a charge of battery on a person 65 years of older, battery domestic violence, which had a bond on it.
Mm-hmm.
Based on the
New law.
based on the allegation of tampering with a witness, the state moved to revoke bond and the court granted that and issued the capias with no bond.
Yes.
Okay,
Judge Blackman on the 26th.
okay.
So I believe he may just be here for that, Your Honor.
Right, that's all I
Bonds
have
were
is the
revoked.
capias. So we're gonna stay those bonds at none per the other judge's order. We're gonna appoint the public defender's office to represent you. They'll take care, or, stay in contact with them. But you have no bond on that case per an order from a different judge, okay? right, ma'am, what is your name?
Ianka Camille.
All right, Ms. Camille. You are here on one count of false imprisonment, one count of battery, domestic violence. Both of those came in at no bond. The court's reviewed the arrest affidavit. I'm not sure there's probable cause for the false imprisonment state. Do you want to, I mean, I think the allegations were that she like stood in the doorway. It's okay. Don't, anything you say can and will be used against you. I'm going to appoint the public defender's office to represent you in this case. So there's your attorney. You can talk to her.
Your Honor, it's my understanding for false imprisonment, the state has to prove that the defendant forcibly, secretly, or by threat confined the victim against their will and had no lawful authority to do so. Arguably, by standing in the door, she confined him to a room that he did not want to be in. He made it clear his intention that he did not want to be in that room. He attempted to exit several times, but she was preventing him from do so. She kept seeing him through the door multiple ways and attempting to exit the bedroom, kept telling her to leave him alone. And I believe the defendant also told law enforcement that she was trying to prevent him from leaving that room. So although thin, state believes that it would be enough for PC at this point. I she had no lawful authority to make Mr. Huntley stay within that room if he did not want to, and his intent was clear, he did not want to be in it.
All right. Court finds no probable cause that relates to the forcibly part, the standing in the way, and I think her admission was that she was trying to keep him from getting into the kitchen, not necessarily from staying in that room. So as it relates to her admission, the court's considering the appropriate weight given to that. But the other stuff, I'm just going to find no probable cause as to the false imprisonment count and ROR on that. With regards to the battery, sir, what's your name?
Brian Huntley.
All right. The court's going to set a bond in this case. Do you want to be heard as it relates to the amount of appropriate bond for Ms. Camille?
Your Honor, I believe she qualifies for PTR. I haven't inquired of the victim yet, so I don't know if he would object. However, depending on his answer, state has no objection to PTR.
Okay, thank you. All right, so she does qualify for something called pretrial release. That's a non-monetary release where she's just kind of supervised by the PTR program pending whatever happens with her case. So is there anything you would like to say about, do you have any objection to her being released on PTR?
She can be released. Like I don't really want to press charges or anything like that. Like
I understand. So are you currently afraid of her in any way?
no.
All right. You guys live together?
Yes, sir.
All right. All right. Defense, you prefer PTR? Would you prefer a nominal monetary bond? What would you prefer?
Pretrial release, Your Honor.
Okay. All right. So we'll release her on pretrial release. Special conditions that you have no hostile contact with the victim. All that means is no fighting. You guys can have contact. It can't be hostile contact. If you saw what happened. You were sitting out here to the gentleman with the injunction. The allegations against him were essentially he had hostile contact, used some words he shouldn't use. No hostile contact means no hostile contact. No F words, no you get out of my, no screaming, yelling, pointing, anything like that. So, yeah, that'll be the only special condition. You guys can live together, just no hostile contact. You can have contact. You guys don't have kids, right?
She's pregnant now.
You're pregnant now? Okay. All right. All right. Anything further? Defense?
Nothing from defense.
State?
Nothing from the state.
All right. All right, sir, what's your name? So what's your name?
Mr. Graham.
All right, Mr. Graham, you are here on one count of aggravated assault, domestic violence. I'll appoint the public defender to represent you in this case. Ma'am, what is your name?
Cheryl Annette White Graham.
All right. Give me 1 second. All right, the court does find there's probable cause. The court is inclined to set a bond. Ma'am, would you like to be heard on the amount of an appropriate bond and any special conditions? Anything you want to say about?
No, I'm not afraid of my husband.
You're not?
No, because he has a lot of medical issues, so sometimes it bothers him and stresses him out. And it just got elevated yesterday.
You guys live together?
Yes, we do.
All right.
And I don't want to press any charges.
I hear you. We gotta do what we gotta do here, okay? But I've heard what you gotta say and I'm considering it, okay? All right. All right. I'm gonna set bond at $2,000, okay? Special conditions that you have no hostile contact with your wife, okay? You can and that you possess no weapons. Ma'am, I'll ask you, I'm not gonna ask, anything you say can and will be used against you, so I'm not gonna ask you. I'm gonna ask, was alcohol or drugs involved in this in any way?
No.
Okay. All right, I'm assuming you possess no weapons. That includes knives, guns, flamethrowers, anything. So possess no weapons. Any weapons that you do have, you got to surrender those to law enforcement within 24 hours of your release, okay? Other than that, bond set at $2,000. Again, yeah, no hostile contact with the victim, okay? All right, ma'am, what's your name?
Helen Gutierrez Cortez.
I'm sorry, say that again?
Helen Gutierrez Cortez.
All right, Mr. Gutierrez, you're here one count of aggravated assault with a deadly weapon and battery, domestic violence. Court's reviewed the affidavit, does find there's probable cause. I will appoint the Office of the Public Defender to represent you. There is, the victim is not present. State, do you have a position on appropriate bond on these, having reviewed the affidavit?
Your Honor, it appears Ms. Gutierrez Cortez has very little criminal history. I believe just potential juvenile arrest. So the state would just ask for $1,500 on one and to treat BAT DV as a subsidiary at 100.
Okay. We're gonna grant bond on count one, that's the felony, the aggravated assault with a deadly weapon at $1,500. On count two, we'll set, on the battery domestic violence, we'll set, bond at $100. The special conditions of your release are that you are to have no contact with the alleged victim in this case. And this is important. You gotta, I understand you're getting some paperwork, but you gotta listen to what I'm about to say. Cause this is a domestic situation. I understand you guys may live together, stay together. Do they live together, counsel? I'm gonna ask your attorney.
Yes, Your Honor.
All right. So because he's not present, I have to order that you have no contact with him, okay? I can't allow you to go back to the house one time with the, in the presence of law enforcement, be that Orange County Sheriff's Office or any other, local law enforcement agency, to get your stuff, okay? So you can go back with law enforcement, get your stuff. Other than that, you can have no contact with the alleged victim. No cell phone, no text messages, no phone calls, no Facebook, no Instagram. If you want to get that modified, that you need to talk to your attorney about that. But because he's not here and I haven't heard testimony from him, I have to order that you have no contact with him. And if you do have contact with him, there's a chance you come back with no bond and you sit in jail for a while. It just depends, okay? So that's very important. You understand? All right. All right. So, yeah, bond set on both of those. You can have a step outside and good luck.
Your Honor, state would also ask for the condition of no weapons, as is a felony, and a weapon was
Okay.
used.
We'll also order that you possess no weapons. That's guns, knives, flamethrowers, anything like that. If you do have any weapons like that you need to surrender those to law enforcement within 24 hours, okay? All right, good luck to you.
Good morning, Your Honor.
Good morning. Sir, what's your name? Yeah, what's your name?
I'm sorry, I thought he said, raise your hand.
No.
My name is Alexis Ripollet.
All right, Mr. Repollet, I have, you're here on 2 counts of, well, 1 count of false imprisonment, domestic violence, 2nd count of battery, domestic violence. I've reviewed the affidavit. I do find there is sufficient probable cause. There is sufficient probable cause. However, you do qualify for pretrial release. State, is there any objection to pretrial release in this case?
Your Honor, pending whatever the victim, she's shaking her head no. State has no objection to PTR.
Okay. All right, ma'am, what is your name?
Rubiana Nieves?
All right, Ms. Ramirez, are you the alleged victim in this case?
Yes.
All right. Your husband, is your husband?
Yes.
All right. He does qualify for a non-monetary release, a pretrial release. It's a form of supervised release. So he would be getting out today if you don't object to that. Is that, so you don't object to that? You got to answer out loud, yes or no?
No, I don't object.
All right. Are you currently in fear of your husband at all? Okay.
No.
I reviewed the affidavit. I think pretrial release is appropriate. We will order as a condition of your pretrial release that you possess no firearms, no weapons. If you do currently possess firearms or any weapons like that, you do need to surrender those to the to law enforcement, be it the sheriff's office or any local law enforcement agency. And also that you have no hostile contact with your wife. I understand, living together, things happen, but, as a condition of your release, that means no yelling, no screaming. You can have contact together, but no yelling, no screaming, no hostile contact, no fighting, essentially, okay? I understand sometimes that's difficult, but be it a condition of your release, if that starts to get that way, you just gotta leave the room or something, okay?
I understand.
Yep.
And I know you saw the affidavit and understand that I do have concern for her safety. So
It's okay, no, yeah. Do you plan on hiring an attorney?
I'll look into, yes, what the best.
All right, in the meantime, I'm gonna appoint the Office of the Public Defender to represent you. Any questions, concerns like the ones you just, run those through your attorney. If you do hire one, just let the Public Defender's Office know, and your attorneys can take it from there. But you will be released as of this charge today under those conditions, okay?
Yes, sir.
All right, thank you. Have a good day. These, I was kind of setting them aside. All right, ma'am, what's your name?
Sir?
All right, Miss Addison. You're here 1 count of battery domestic violence. I'm appointing the Public Defender's Office to represent you. I've reviewed the affidavit. I do find there is probable cause. State, do you have if she does qualify for PTR, is there any objection? I know the alleged victim's not here, but is there any objection from the state at this time?
No, Your Honor. And I also believe DCF was contacted in this case as well.
Right. All right, so we're gonna release you under what's called pretrial release. That's a non-monetary release, but there is conditions, all right? And there's some supervision, so it's a supervised release. It's almost like probation, okay? As a special condition of that probation, you're to have no contact with Mr. Streeter, okay? That means no text messages, no Instagram, no Facebook, until further order of the court. Because he's not here today, I do have to order that you have no contact. Do you two live together?
No, sir.
All right, so you don't need to go back to the house for any reason to get anything like that?
But that's my house. He don't live there at my house. No, he's not there. He
Okay.
lives on the property. Yes, sir.
All right, so if it's your house, you can go to your house, obviously, but you are to have no contact with him, okay? So that's, like I said, text messages, Facebook, Instagram, you can't tell, do you have kids together?
We have a child.
Right, can't communicate with him through the child, tell your dad this, whatever, nothing like that, okay? That's a condition of your release. If you violate those conditions, there's a chance you come back in with no bond and you sit here for a while until we can figure it all out. But just to be safe, stay away from each other while this is going on, okay? Not only to be safe, it's a condition of your release, okay? All right, anything further?
No.
Your Honor, is there anything with DCF? Comply with DCF?
I didn't see where DCF was.
DCF was notified at the bottom and top of the
Let me
affidavit.
see. Okay. All right, DCF was notified as a condition of your release also. If DCF imposes any conditions, you're to comply with the conditions of DCF. If they don't, they don't, but if they do, a condition of your release is to comply with those DCF conditions, okay? All right, thank you. right, sir, what is your name?
You want the-
Your Honor, could we see Ms. Madden, Lauren? I believe they both,
Bring him in at the same time?
yes, Your Honor.
I mean,
It's Lauren Madden or Haley Figueroa, right? It's the same.
Yes, Your Honor.
All right. All right, man, what is your name?
Haley Figueroa.
All right, Ms. Figueroa, and your name was Mr. Artis? All right. You guys are both here on one count of battery dating violence. Ms. Figueroa, you also are here under an alias of, what was it, London?
Lauren Madden.
Lauren Madden. And that was a separate case, that was a petty theft
Yes.
case in front of Judge Bigney, correct? All right. All right, and I believe in the petty theft case, does she qualify for pretrial release?
He does.
She does, okay. All right, so you both qualify for what's called pretrial release. Pretrial release is kind of like probation, except it's supervised release while your case is pending, but there's some supervision, okay? Let me ask you, are you two, well, I'll start with you, Ms. Figueroa, are you scared of him?
No.
All right, are you scared of her? All right, do you guys live together? You do live together?
Yes, sir.
Okay. All right, so I'm going to order you, let's start with Mr. Artis. I'm going to order you released on pretrial release. That's a non-monetary release. It's just some special conditions. The special conditions that are going to be important to you and this, I'll tell you separately, but I'm going to tell him so you can listen, so you can hear it twice, is that you two have no hostile contact with one another. That means no fighting. Okay, if things start getting heated, you guys got to walk away. If you start screaming at each other, that's hostile contact. Any type of arguing, fighting that gets elevated to the point where you guys are yelling at each other, that's hostile contact. That'll be a violation of the conditions of pretrial release. You can be picked up, be brought back on no bond, and sit here until your case resolves, okay? So it's important that you comply with that. You two can live together. If you have any weapons, guns, ammunition, knives, flamethrowers, if you have anything like that, you need to surrender those to law enforcement within 24 hours, and you are not to possess any weapons the entire time you're on pretrial release, okay? With regards to your other case, Ms. Figueroa, the warrant came in as pretrial release, so you're gonna be on pretrial release on both cases, okay? Same conditions. Just same conditions, okay? I'll appoint the public defender's office to represent you, each of you. There anything further?
Nothing from defense, Your Honor.
All right, you guys don't have any kids, right? All right. All right, so that should take care of both of Miss London. Sorry, I'm gonna say Miss London. Why does it keep saying that? I don't know. So what's the alias?
Lauren.
Lauren Madden.
Mm-hmm.
Okay, sorry. Anyway, so that takes care of the one on, for our side, Lauren Madden and Haley Figueroa, and also DeMarco Ortiz, okay? All right, you guys can have a step outside. You should be released as to those today.
Okay, thank you.
You're welcome. Let me give you the Lauren Madden.
Oh, no, I'll put it together.
You did? Oh, thank you. All right, sir, what's your name?
Tavian Blocker.
All right, Mr. Blocker, you're here one count, or two counts of battery, touch or strike. Did this come in as domestic state?
I believe so, Your Honor.
What's it, you don't?
I do.
Yeah, I thought so too. So, it's
I believe it's alleged that they have an ongoing relationship for 6 years.
right, okay. So it's one count of battery, domestic violence, and then simple assault, intent. And both of those came in at no bond. I've reviewed the affidavit. No, I do find that there is sufficient probable cause based on the affidavit. I am inclined to set a bond. The alleged victim's not here. I will appoint the public defender's office to represent you. State, do you have a position as to appropriate bond?
Your Honor, it doesn't appear that there has been any prior history between Mr. Blocker and the alleged victim. From the paperwork I have, he does qualify for PTR.
I do see that.
State has no objection to him being on PTR.
All right, so you do qualify for something called pretrial release. Pretrial release is kind of like probation, but it's a non-monetary supervised release. There's some conditions. So you don't have to pay a bond, but when you get out, there's some conditions that you have to comply with, or else you get arrested for violation of pretrial release, okay? So the special conditions of pretrial release, based on the affidavit, and the fact that the victim's not here, that you have no contact with the alleged victim, okay? That's no Facebook, no Instagram, no text messages, no communicating through third parties. You have no contact. Do you guys live together?
Yeah, yes, sir.
Okay. Here, I appointed the public defender's office to represent you. Anything you say can and will be used against you, so I don't want to ask you about the facts of your case. The purpose of today's hearing is just a set of conditions of your release, okay?
And Your Honor, did you provide a one-time return with law enforcement?
I was gonna do that, but yeah. All right, because you two, again, the conditions are no contact until modified. If you want to get that modified, she has to show up and we have to have some contact with her to consider her testimony, okay? Because she's not here, don't say anything. Just, I gotta do what I gotta do since she's not here, okay? I understand some things you want to say, anything you want to say, just run it through your attorney. You're gonna get out as to this charge today. The conditions are that you have no contact with the alleged victim. You can return to the residence one time under the accompaniment of law enforcement, sheriff's office, any other local law enforcement agency. You can go back and get whatever you need out of the house until the court's order is modified. You are still to have no contact and also possess no weapons, firearms, knives, ammunition while you're on pretrial release. Okay, until that's modified. But other than that. Yeah, no contact with the alleged victim, possess no weapons, and one-time return to the residence under the accompaniment of law enforcement to retrieve any personal belongings, okay? All right, ma'am, what's your name?
Elizabeth Frias.
All right, Ms. Frias, you're here one count of battery, domestic violence. I reviewed the arrest affidavit. I do find there is probable cause based on the arrest affidavit. I'm going to appoint the public defender's office to represent you. You do qualify for pretrial release. State, is there any objection?
Your Honor, I believe the victim is approaching.
Okay,
I believe he's on a scooter.
okay. I didn't see him in there. Thank you. All right, so the alleged victim is here. We're going to hear from him as it relates to any conditions of your release, okay? All right, sir, what's your name?
Felipe Frias.
All right, Mr. Frias, are you the alleged victim in this case?
Yes, sir.
All right. Your wife qualifies for something that's called pretrial release, which is a non-monetary release, so she would get out today. Do you have any issue with that?
I'm very afraid about my life. Yesterday, before she left, she told me, I would have the pleasure of filling your body with bullets, and I'll come in the middle of the night and kill you. So I'm very afraid for my life. There's guns and ammunition in that house, and her son is also very aggressive with me.
Okay.
I'm very
Right, so you
afraid
don't
for
wish to
my
have
life.
any contact with her, and you wish that, you want the court to order that there be no contact between you and her?
Please, sir.
Okay. All right. If I haven't already, I'm going to appoint the Public Defender's Office to represent you. State, having heard that, is there any objection to pretrial release?
Your Honor, I believe pretrial release may be best, so there'll be some supervision, as opposed to just straight bonds, just they would ask for PTR given the victim's testimony.
I agree with that. So, Ms. Frias, you do qualify for what's called pretrial release. Pretrial release is a non-monetary release, so you would be released as a charge today, but there are strict conditions related to your release. One of those conditions that the court's going to order is that you have no contact with your husband, the alleged victim in this case. It also, one of the conditions that you possess no weapons, no firearms, no ammunition. If you have any of those, if you do, if you don't, you don't. If you do have any of those, it's going to be a condition of your release that you surrender those to law enforcement within 24 hours, okay? Well, also, you guys live together? I'm not asking you, I'm going to ask him, because anything you can say can will be used against you. You're the one that's here charged with a criminal offense, so I would rather ask him. And, you know, it's not because I prefer his testimony over yours. I just don't want you saying anything that may be used against you later, okay? All right, sir, do you guys currently reside together?
Yes, sir.
All right. So based on that, I am going to allow you a one-time return to the residence to get your personal belongings. But you can't stay there. And you can only go under the accompaniment of law enforcement. So you can't go by yourself. You got to go take your court paperwork, go to the appropriate agency, the sheriff's office, the local police department, whoever it is, and tell them you got a one-time return. They have to go with you, and you can get your personal belongings. There's been some testimony that there's guns and ammunition in that residence. You're to take none of that, okay? Not even to surrender that to law enforcement. That's going to stay in the house that you can't return to other than that one time, okay? If you personally possess any weapons or firearms, like I've said, you've got to turn those in. But your one-time return, you can get personal belongings and then leave, and those personal belongings do not include any weapons, okay? All right? Anything further?
No, Your Honor.
All right, anything further for you, sir?
No, sir. Thank you.
What's that? I couldn't hear you.
Thank you, Your Honor.
All right, thank you. All right, ma'am, what's your name?
Samantha Gordon.
All right, Ms. Gordon, you're here in one count of battery domestic violence. I have reviewed the arrest affidavit. I do find there's probable cause. No one, the alleged victim's not here. I will appoint the Public Defender's Office to represent you. Say, do you have a position? The court's inclined to set a bond of $500. Do you have a position?
The state has no objection, Your Honor.
Okay. I'm gonna set your bond at $500, okay? A special condition of your release, should you bond out, or even if you don't bond out, you're to have no contact with the alleged victim in this case. You two don't live together, right? Right. Okay, so you have no contact, you have no need to go back to the residence to get any personal belongings or anything like that. All right, so as a condition of your bond, you're to have no contact with the alleged victim. That's no text messages, no emails, no Facebook, no Instagram, no IMs, no DMs. Don't communicate through any children, any third parties, no contact, okay? If you want to get that modified, you have an attorney representing you, you can get that modified, but as we sit here today, until that's modified, you're gonna have no contact with him, okay? All right. Yeah, you have a step outside, and yeah, thank you and good luck.
Your Honor, was there a no return? I believe it's alleged that.
Yeah.
With
That's
his
not your house, so
residence.
and also don't return to the residence, okay? Thank you. All right, ma'am, what's your name?
Zulema. Lorente Borrero.
Okay. All right, ma'am, you're here on one count of battery domestic violence. I will appoint the public defender's office to represent you. I've reviewed the arrest affidavit, do find there is probable cause. And the court's inclined to set a $500 bond on this count as well. Is there any objection?
No, Your Honor.
All right, ma'am, so I'm setting your bond at $500, okay? A special condition of, do you stay at the residence? You do live at that residence? Okay,
I'm the owner.
it's your house.
Yes.
Do they live with you?
Yeah, but she left last night.
Okay. All right. You can go back to your house, you can go back there. But you're to have no contact with the alleged victim. That's emails, text messages, through third parties, no contact. Do you know where is she planning on coming back, or do you know?
No, I don't think so.
Okay.
Your Honor, so we just ask that you set separate residences in case that she is there. So the defendant can
Right.
leave.
We'll just require you maintain separate residences. It's your house. If you don't want her living there, obviously, but if she, for whatever reason, she comes back and starts living there, then you gotta get out, okay? Order that you maintain separate residences, that you have no contact with the alleged victim. Other than that, your bond's set at $500, okay? All right, thank you.
Just throw it out of county.
Yeah.
Whatever they have.
All right, sir, what's your name?
Perry.
All right, Mr. Perry. You're here on a out-of-county warrant. Came in no bond. Court's gonna stay that bond. Can we appoint the public defender? I mean, he doesn't have an Orange County case, so I don't think we can. Yeah, I don't think I can appoint the public defender to represent you on this case because it's not an Orange County case. It's so we're just gonna leave the bond at none, and whatever happens with out-of-county case is gonna happen, okay? All right, so good luck to you, sir. Huh?
Yes.
That's probably what's gonna happen. But, all right, so good luck to you, sir. All right, so, ma'am, what's your name?
Juanita Wells.
All right, Ms. Wells, you're similar situation as, gentleman before you. You got a warrant out of Volusia County. One of them came in no bond. The other one has the other count has a $2,500 bond.
Actually, Your Honor, it's a blanket bond, so
Okay.
the total bond is $2,500.
Okay, so the total bond in your out-of-county warrant is $2,500. There's also, we're on probation from you weren't on probation in Osceola County?
No.
Well, I'm thinking of a different case.
It's
He's
out
out
on
on
bond.
bond.
You're out on bond in a Osceola County case? Okay, all right. Well, be that you were out on bond on the, when was the bond on,
Your Honor, they would request that you take no action. We don't know the date of incident for the Volusia County case, so we don't know if she actually violated the
right,
Osceola.
that's what I was gonna
The state
try to
would-
get to the bottom of, so we don't know.
We request no action.
When was she, when was the bond in the, when was the bond on the Osceola County case? Can you tell us that? I'm just curious.
The
I heard-
bond on the Osceola?
Yeah. Here's what we're gonna do. While they're looking that up, I was just curious. So you got $2,500 bond on your out-of-county warrant, so you can bond out on that. I'm gonna take no action on the Osceola County case because we don't know, if that, and I'm not asking you. So don't say anything, anything you say can well be used against you. We don't know when the Volusia County case happened. If it happened while you were out, like I said, if it happened while you were out on bond and there's a probable cause determination that it happened while you were out on bond, there's a chance that bond in the Osceola County case may get revoked and you come in no bond. But as it sits here today, we're gonna take no action on that, okay? Anyway, so we're gonna stay the bonds on your out-of-county warrant at $2,500, okay? All right, good luck. All right, sir, what's your name? Crespo? Are you? Okay. All right, for Mr. Atkinson, we'll just stay his bond at none.
And I will waive, Your Honor, if you appoint.
Okay. All right, Mr. Crespo, you came in here on a violation of probation warrant that was signed by a separate judge that came in no bond. We're going to stay the bond at none. We'll appoint the Office of the Public Defender to represent you. Make sure you have their information, and then, yeah, you can have a step outside, okay? Atkinson, Crespo. All right, sir, what's your name? All right, Mr. Huber, you're here on a violation of probation, came in on a warrant that was issued with, one second. Issued by Judge Roche, it came in under no bond. We're gonna stay the bond at none. We're gonna appoint the Public Defender's Office to represent you, but in the meantime, you're gonna be held on no bond on that warrant, okay? All right, have a good day.
And that's both cases, Your Honor?
Yes, both cases.
He only has one case.
Oh, he only has one, yeah. Lowe has, that was Hoover.
He only has one case.
Lowe, ma'am, what's your name?
Princess Lowe.
All right, Ms. Lowe, you have two cases, I believe. Yeah, 2019 CF 13234AO and 2020 CF 417AO. Both of those came in violation of probation warrants with no bond. We're going to stay those bonds at none, so you'll be held in no bond on those warrants until further order of the court. I'll appoint the Public Defender's Office to represent you. All right? All right, sir, what's your name?
Good morning.
So what's your name?
Theodore McCarthy.
All right, Mr. McCarthy, you're here on a violation of community control warrant that was signed by Judge Barber that came in at no bond. This court's going to stay that bond at none, so you're going to stay here with no bond until further order of the court. I'm going to appoint the Public Defender's Office to represent you. Any question, anything you say can and will be used against you. I don't want you to say anything.
About that.
All right. You have an attorney.
Who violated me? I already have an attorney.
Well, you want to contact that. All I have is a warrant. All I have is a warrant signed by a judge that's reviewed your case and issued a warrant for your arrest with no bond. So that's today's just your first appearance. Any issues you have with who violated, the questions that you may have, is it brought to the court's attention at a different time. Not this court. It's going to be the judge who issued the warrant. So all I'm doing today is staying the bond. You're going to be held no bond until that gets worked out. We're not going to work it out here today. It's just not how it works, okay? But if you have an attorney, best move is to contact that attorney. In the meantime, I have appointed the Public Defender's Office to represent you on the VOP, because sometimes your attorney represented you on the underlying. I'm just telling you. I've appointed the Public Defender's Office to represent you, just in case you have trouble getting in contact with your attorney who you've hired. You can work with the Public Defender's Office if that, you got two attorneys essentially until one of them withdraws, okay? So you got two attorneys working for you. Your concerns, and I understand them, are better addressed through them, okay?
Yes, sir. Yes, sir. My bad.
Yep.
The last girl, Lowe, she had a private attorney.
She did?
For her cases.
Oh, that's right. Bell or
And King.
King. Now, the VOPs is kind of weird. Sometimes they show up. When
No, it's recent.
It's recent? Okay. All right, thank you. All right, sir, what's your name?
Kendall Pearson.
All right, Mr. Pearson, you are here on a violation of probation warrant. It came in at no bond, same thing as the gentleman before you. The judge that issued the warrant issued no bond. This court's going to stay that bond until further order from that court. So you're going to be held no bond until further order of the court, okay?
When's my next date?
I think it's soon. I think it's like, when I looked at it earlier, I think it's like tomorrow. Yeah, tomorrow.
Is that over here? That's not downtown, that's over
It's
here?
in front of Judge Lattimore when she comes out here, right? Yeah, it'll be out here.
Okay, I have a lawyer down here. Should I call him for this next?
If you have a lawyer and you're in jail, it's a good idea to call him.
Thank you.
Yep. That's it, right? The last. Yeah. 33-day motions? Oh, okay. All right, so 33-day motions. First one I have is Octavius Jackson.
22.
And Madam Interpreter, if you can't tell, we are at first appearances at.
Thank you.
All right, sir, good afternoon.
Buenas tardes, señor.
You are, and the other Spanish speakers, this is for your benefit as well.
Esto se lo digo tanto a usted como a las otras personas que necesitan el intérprete en español.
You are entitled to be represented by a lawyer, and you can hire a lawyer if you wish.
Usted tiene derecho a estar representado por un abogado y si desea podría contratar uno.
For today's purposes, I am provisionally appointing the Office of the Public Defender to assist you.
Pero para propósitos de la audiencia de hoy, yo estoy designando provisionalmente a la oficina del abogado de oficio para que les represente.
If you wish to have court-appointed counsel, the court will appoint counsel unconditionally if you qualify once you complete the required financial affidavit.
Si usted desea que el abogado de oficio continúe representándole a través de todo el caso, tendrá que llenar la solicitud y si cumple con los requisitos se le designará. Okay.
All right. Sir, you were arrested for the charge of operating a motor vehicle without a valid driver's license.
Señor, usted fue puesto bajo arresto por conducir un vehículo de motor sin licencia válida.
Officer Jenkins, I have a question. I see that the stop involved alcohol. Was there a separate charge or no?
No, that's the only charge that we have, to operate the motor vehicle without a valid driver's license.
Okay.
Tengo una pregunta. Veo aquí que en la detención en el alto hubo alcohol. Le pregunto a la licenciada si se le presentó alguna acusación adicional. No, la única que tengo en el sistema es la de conducir sin licencia válida.
All right, there is probable cause for the arrest.
Existen indicios de criminalidad para el arresto.
Sir, you do not qualify for non-monetary pretrial release.
Señor, usted no cumple con los requisitos para que se le conceda libertad a través del programa de libertad provisional sin tener que prestar fianza.
I'm curious, does anyone know why the bond amount was reduced and he was held at zero bond?
Probably because he came in as a John Doe.
¿Alguien sabe por qué se redujo la cantidad de la fianza y se le impuso prisión preventiva? Probablemente porque originalmente se le atendió como un John Doe.
All right, so I'm going to reduce your bond to $250.
Muy bien, señor, voy a reducir la cantidad de su fianza a $250.
You will receive notice of future court dates from your bond surety if you have one and through the public defender's office. You need to make sure the clerk of court has your correct mailing address.
Usted va a recibir las notificaciones de las próximas audiencias a través de su fiador, si es que utiliza alguno, y si no, a través de la oficina del abogado de oficio. Así que, por favor, asegúrese de mantener actualizada su dirección en secretaría.
Your Honor, I have a court date for him.
Okay, and we have a court date for you. Madam Clerk is going to announce.
Tenemos la fecha de la próxima audiencia disponible. La señora secretaria de sala la mencionará a continuación.
If still in jail, September 8th, 8:05 a.m., courtroom 4A.
Si aún se encuentra usted en la cárcel, la próxima audiencia será el 8 de septiembre a las 8:05 de la mañana en la sala 4A.
If bonded, September 20th, 8:30 a.m., courtroom 5B.
Si ha prestado la fianza, será el 20 de septiembre a las 8:30 de la mañana en la sala 5B.
All right, thank you, sir.
Gracias, señor.
Next case, Jose Aguirre Garcia. We have two cases, 22 CF 2527, 22 CT 2965. Good afternoon, sir.
Buenas tardes, señor. Good afternoon.
Sir, in 22 CT 2965, you were arrested for operating a motor vehicle without a valid driver's license.
Señor, en cuanto al caso 22 CT 2965, se le acusa de conducir un vehículo de motor sin licencia válida.
There was probable cause for that arrest.
Existen indicios de criminalidad para ese arresto.
In case number 22 CF 2527, you were arrested for possession of cocaine pursuant to the search following your arrest on the other charge.
Y en cuanto a la acusación 22 CF 2527, se le acusa de tenencia de cocaína. Esta cocaína fue hallada en el registro hecho posterior al arresto inicial.
There is probable cause for that arrest as well.
Existen indicios de criminalidad para ese arresto también.
You do not qualify for non-monetary pretrial release.
Usted no cumple con los requisitos para participar del programa de libertad provisional sin tener que prestar fianza.
I'm going to reduce your bond on CT 2965 to $250.
Voy a reducir su fianza en el caso 2965-2022 CT a $250.
I'm going to reduce your bond on the CF 2527 case to $1,000.
Y en cuanto al caso CF 2527, la fianza se reduce a $1,000.
Conditions of bond are that you may not possess or use drugs or narcotics without a valid prescription.
Como condición de su fianza, se le prohíbe la tenencia y uso de drogas o narcóticos sin receta.
Must maintain contact with the public defender's office.
Tiene que mantenerse en comunicación con la oficina del abogado de oficio.
And Madam Clerk, what are the next court dates?
Y le pregunto a la señora secretaria de sala cuáles son las fechas de las próximas audiencias.
For 22 CT 2965, if in jail, September 8th, 8:05 a.m., courtroom 4A.
En cuanto al caso 22 CT 2965, si se encuentra aún en la cárcel, la próxima audiencia será el 8 de septiembre a las 8:05 de la mañana en la sala 4A.
If bonded, arraignment, September 21st, 10 a.m., courtroom 4A.
Y si ha prestado la fianza, la vista incoatoria será el 21 de septiembre a las 10 de la mañana en la sala 4A.
All right, thank you, sir.
Gracias, señor.
Yes, I accept the name. I assume that was verified through fingerprints, Officer Jenkins?
Yes, sir, and IDs.
All right, and IDs, so yes. All right, Harry Claudio Salgado, case number 2016 CF 3020. Good afternoon, sir.
Buenas tardes, señor. Good afternoon.
Sir, you were arrested for an on-view violation of probation.
Señor, usted fue puesto bajo arresto por haber incumplido con el régimen de libertad vigilada.
And that was pursuant to warrantless search by the probation officer.
Y eso fue a razón de un registro que fue hecho por el oficial del régimen.
You do not qualify for a bond because of your status.
Debido a su situación, usted no cumple con los requisitos para que se le conceda fianza.
All right, and the public defender has been temporarily appointed to represent you, sir. If you wish to be represented by appointed counsel, you need to complete that required affidavit.
Se le ha designado el abogado de oficio para que les represente provisionalmente. Si usted desea que el abogado de oficio continúe representándole, tendrá que llenar la solicitud.
And Madam Clerk, does he have a upcoming court date?
I'm sorry, go ahead.
Go ahead, ma'am.
Le pregunto a la señora secretaria de sala, ¿él tiene ya las fechas para las próximas audiencias?
VOP arraignment, September 12th, 8:45 a.m., courtroom 5F.
La fecha de la vista incubatoria por haber incumplido con el régimen de libertad vigilada será el 12 de septiembre a las 8:45 de la mañana en la sala 5F.
Thank you, sir.
Gracias, señor.
Our fourth case is Enrique Palermo Quiles, 22 MM 1996. Good afternoon, sir.
Buenas tardes, señor. Good afternoon.
Sir, you were arrested for domestic violence battery.
Señor, usted fue puesto bajo arresto por agresión física por violencia doméstica.
It seems to be a weak case, but there is probable cause.
El caso parece ser flojo, pero existen indicios de criminalidad.
I'm going to order that you have no contact with Kishila Cuadrado Pagan.
Se le prohíbe todo tipo de contacto con Keshila Cuadrado Pagán.
The only exception is that you may have indirect contact through a third party for purposes of arranging child visitation and child care.
La única excepción es que se le permite tener contacto a través de terceras personas solamente con el propósito de hacer los arreglos para las visitas con el menor y el cuidado del menor.
It seems that you do not share a residence with the alleged victim, so I'm not going to address living arrangements.
Parece ser que usted no convive con la presunta víctima, así que no vamos a atender el asunto de los arreglos de vivienda.
All right, so I need to set a bond. Based on what I'm reading, I'm going to set your bond at a low amount. I'm going to trust that you're going to abide by those conditions. If you violate the conditions I just announced, you'll be back in jail without a bond.
Bueno, en cuanto a la fianza, le voy a conceder una cantidad pequeña de fianza. Yo confío en que usted va a cumplir con las condiciones de la libertad bajo fianza, pero le advierto que si incumple con ella, regresará aquí a la cárcel y se impondrá prisión preventiva.
You understand the conditions I announced, sir?
Señor, ¿usted entendió las condiciones que yo anuncié? Yes.
All right, perfect. All right, I'm going to set your bond at $100 with pretrial release conditions.
Muy bien, así que entonces la fianza es $100 con la supervisión del programa de libertad provisional.
Mr. Rossini, would you visit with him about weapons and firearms? I need to order that he not possess any weapons and firearms. If you could have a brief conversation.
Licenciado, por favor, ¿podría tener usted una conversación breve con él acerca de las armas y las armas de fuego? Porque es que tengo que ordenarle que se le prohíbe la tenencia de mismas.
Yes, Your Honor, I will be explaining after we are done with these proceedings, just because the conversation with the language barrier will take me a couple more minutes.
All right, no worries. Sir, you may not possess any weapons or firearms. If you have any, they will have to be removed from your home before your release, and that will have to be verified.
Su señoría, voy a hablar con él en más detalle una vez hayamos terminado, ya que debido a la barrera del idioma me tomará Más tiempo. Muy bien. Señor, se le prohíbe a usted la tenencia de todo tipo de armas y armas de fuego. O de ser usted titular de alguna, tendrá que entregarla a las autoridades luego de ser puesto en libertad.
Thank you, sir.
Gracias, señor.
Madam Interpreter, would you ask once more if anyone else needs your assistance?
¿Alguna de las personas que permanece en la cárcel necesita los servicios del intérprete al español?
All right, thank you, sir. Thank you, Madam Interpreter. We appreciate you.
Thank you, Your Honor.
All right, the next case is Gabriel Luis Ruiz. I don't have oh, this is not the one.
He is President of Virginia.
Yeah. All right, good afternoon, sir. Sir, you were arrested on a warrant out of Seminole County for failure to appear at arraignment. The judge in Seminole County set a bond in the amount of $1,000 for you. If you're unable to post bond, you'll be transported to Seminole County where you will see the judge and you can address your case and any conditions of release there, okay? All right, thank you. Akeem Lovett, 22 CF 1051 1051. Good afternoon, Mr. Lovett. Sir, you are arrested on a warrant issued by the emergency duty judge for burglary to an occupied structure, criminal mischief of $1,000 or more, and petty theft. There is probable cause. Your bonds are going to be on count 1, $10,000, count 2, $5,000, count 3, $250. Conditions of bond are that you may not possess any weapons or firearms. You may not return to 2385 North Orange Blossom Trail in Kissimmee. That's a Dunkin' Donuts. May not have any contact with Valerie Rojas. You are out on ROR in case number 22 CF 3967. Your probable cause arrest is a violation of your ROR, so your ROR will be revoked in the Orange County case. You'll be held in that case with zero bond on pretrial detention pursuant to statute. All right, thank you, sir. All right, Charles Robertson. Our next case, 2019 CF 101.
Defense would request a waiver of the reading of the underlying, Your Honor.
All right. Good afternoon, sir.
Good afternoon,
All right, so you were arrested for a failure to appear way back in July of 2019 is when that warrant was issued. There is no bond. Does Mr. Robertson have a court date?
Status hearing, September 6, 8:30 a.m., courtroom 4F.
All right, thank you, sir. All right, then we have case number 22 CF 1359. This is Kasai Tafari Sanderlin.
Is President approaching, Your Honor, as with the last defense would request a waiver of the reading of the underlings?
All right. State, I have a question about this one. The qualifying offense seems to have been committed when Mr. Sanderlin was a juvenile. Is he entitled to a bond? Because the judge who issued the warrant set a bond, but this is typically the kind of case and the kind of violation where there would be zero bond required by law.
Your Honor, my understanding, he's not entitled to a bond.
What's that understanding based on?
Based on the charges, Your Honor, the underlying charges.
The underlying charge was as a juvenile. Does that affect the?
I don't believe so, Your Honor. I can see if.
I have a concern about whether Jessica Lunsford applies. I typically do not touch other judges' bond determinations. But if a bond is not allowed by law, I'm not going to ratify that. If a bond is allowed by law, the judge can reset it. So So you were arrested on a violation of probation warrant for violating a condition of community control. I'm going to set your bond at 0. You have the public defender appointed. They can get your case back in front of the division judge to move for a bond. And if that judge wants to grant you a bond based on the circumstances, she can certainly do so. Okay?
Your Honor, he has a VOP arraignment for September 6, 9 a.m., quorum 5A.
Okay, thank you. Thank you, sir. 22 CF 2528, this is Emmanuel Cruz Lazardi.
He's present and approaching, Your Honor.
Good afternoon, sir. Sir, you're arrested for domestic battery by strangulation. There is probable cause for the arrest. I don't have a victim here today. Do you have a place where you can reside other than 4102 Bobby's Court, apartment 201?
Yes, sir.
All right, who with?
Sorry?
With whom?
With another friend.
Okay. All right, so you're entitled to pretrial release. I do not have a witness here, so I'm going to issue the standard conditions of release. Based on what I'm reading, I think a lower bond would be appropriate. So I'm going to set bond at $500 with pretrial release conditions. However, you may not have any contact with the listed victim, Amber Nicole Concepcion Cosme. The only exception would be you can have contact through a non-hostile contact through a third party with regard to child visitation and child care. You can't contact her directly. It has to be non-hostile and through a third party. Do you understand, sir?
Yes.
All right. You may not reside at 4102 Bobby's Court, apartment 201. You have to reside somewhere else. If you have personal belongings there, you can return one time with law enforcement to obtain your personal belongings. Otherwise, you have to maintain a separate residence. Finally, if there is a case plan through the Department of Children and Families, you must comply with that. Okay? Thank you, sir. All right, Valerie Dixon, 22 MM 1994.
Yes, Your Honor, she's in the back. It'll be a moment before she is brought forward. While defense does not have a probable cause argument, they would like to be heard on release conditions, Your Honor.
Yeah, I see that she is on conditional release. She has been found incompetent to proceed.
Yes, Your Honor, she is actually my client in one of those cases.
Okay. All right, good afternoon, ma'am.
Hello.
Ma'am, you were arrested for trespass after warning, and there is probable cause for the arrest. I'm going to order that you not return to 101 West Cypress Street, which you've been ordered to stay away from previously. Mr. Mancini, do you have argument with regard to conditions of release?
Respectfully request that this court consider ROR in this case. I know that adjudicating incompetence is not the job of the IA judge, but I believe it is now almost I believe it is now 3 cases, if not maybe just 2, that she's been found incompetent to proceed. We've adopted those findings. I believe we just got her released last week. This is an ongoing mental health concern, and she can receive better treatment if given a Baker Act hold, which I believe is likely in this case. I would ask the court to consider ROR in this case, or at least not revoking any of the previous status in her prior cases, Your Honor.
Well, I mean, typically what I would do, State, you want to be heard?
Your Honor, I know defense mentioned that she's been found incompetent to proceed, but I don't see that under the most recent case involving the same parties, 22 MM 1752. I believe motions have been filed and it's set for hearing. And additionally, she hasn't been found incompetent to proceed in this case. So State would ask that she be given a bond with conditions of release, Your Honor.
Are you telling me Mr. Massini, that the jail is going to pursue a Baker Act?
I believe it would be likely in this scenario based on her condition at this moment and what usually occurs when they're brought in. I know the procedure is to, with clients with this status, especially ones who have been repeat to cycle through, to be brought through a mental health screening before they're released, and then are usually, with the types of clients in this situation, placed on a Baker Act hold and sent to Park Place when they are granted release.
Officer Jenkins, do you have any information about that?
No, sir, I wasn't told.
All right. Let me take a look at something real quick. All right, she was released in both cases, I believe.
I believe that is correct, Your Honor.
Yes.
All right, here's what I'm going to do. I understand the sensitivity of it, and I'm sensitive to that myself. But I also don't have complete picture of what's going on at the jail. So I'm going to grant ROR on the current case.
Yes, Your Honor.
I am going to revoke conditional release in the other two cases so that the division judge or judges who are familiar with Ms. Dixon can address her. And if the jail is going to do something, they are not constrained from doing that.
Yes, Your
Based on my order. And then I think that's the safest way to proceed.
Yes, Your Honor, understood. Thank you.
Thank you. All right, 22 CF 2529, Melvin Johnson.
Yes, Your Honor, he is present and approaching. Defense would have a probable cause argument to one of the charges in this affidavit, Your Honor.
Okay. All right, good afternoon, Mr. Johnson. All right, sir, you were arrested for grand theft, for violation of the Florida Pawnbroking Act, and for dealing in stolen property. Your attorney has a probable cause argument, so go ahead, counsel.
Yes, Your Honor. I believe, as you stated, this was charged under Florida statute 539.00117, subsection B. Specifically, that part of the act seems to be targeting employees or pawnbrokers or employees of pawnbrokers who are filling out paperwork in their role as a pawnbroker, and not specifically people who are dealing in stolen property, because there is a whole separate charge for that. It is my reading of the statute that this act, and most of it, applies to people who are acting as pawnbrokers or pawnbrokers' employees. My client is neither of those things, and I would ask that the court not find probable cause on that charge, Your Honor.
So I'm not familiar with what a cell phone purchase kiosk is. Showing my age, but do you have a response to the argument?
Your Honor, just that I believe the officer just cited the wrong statute. There is a form when you turn in the property to the machine or to a pawnbroker that you're attesting that it is your property and it's not stolen property. So I believe that was the statute the officer was citing to. I was going to pull it up. One moment, Your Honor.
Your Honor, if I may have a brief response.
Sure, but let me make sure she's finished.
Yes, Your Honor.
Your Honor, he can go ahead and I can get the correct statute for you if you'd like.
All right, go ahead, Mr. Massini.
Yes, Your Honor. I would just like to state for the record that while the officer may have intended to cite a different part of the statute, that was not what was cited in this sworn affidavit. It is what is alleged to have been violated, and as of such, today there is no probable cause for that charge, Your Honor.
I'm looking at the statute cited now. So the statute cited is actually about criminal penalties, not about the prohibited conduct.
Yes, Your Honor. But I believe with the intent of the statute, along with the sections that say, talking about records, that it's specifically referring to records kept by pawnbrokers or pawnbrokers' employees, and not specifically people who are dealing in goods with pawnbrokers or our customers.
Pawnbroker means any person who is engaged in the business of making pawns, who makes a public display containing the term pawn, pawnbroker, or pawn shop, or any derivative thereof, or who publicly displays a sign or symbol historically identified with pawns.
Yes, Your Honor, I do also
A
believe.
pawnbroker may also engage in the business of purchasing goods, which includes consignment and trade. So I'm going to find no probable cause because the affidavit doesn't describe why this would satisfy the definition of a pawnbroker as well. I'll give the state 24 hours to file an amended affidavit as to count 2. I do find probable cause as to count 1 and 3. Count 1 is tenuous, but I think there is some probable cause there. Bond on count 1 is going to be $500. Bond on count 2 is $2,500. Actually, strike that. You qualify for direct pretrial release, Mr. Johnson. So I'm going to grant direct pretrial release conditions for you, okay? All right. Anything else, State?
Your Honor, just that the pre-trial release conditions involve no contact with the listed victim in this case.
All right, so I will set pretrial release conditions to include no return to Walmart at 4444 West Vine Street and no contact with Mr. Mashburn, Terry Mashburn. Okay?
Yes, Your Honor.
Count 1 and 3 are straight PTR.
Correct. And the state has 24 hours to file an amended affidavit with regard to count 2.
So should I put count 2 as ROR?
Count 2, no, it will be reheard tomorrow, reset for tomorrow on count 2. Okay, thank you, sir. All right, the next case is Miguel Alejandro Nieves, 22 MM 1995.
Your Honor, I believe he is still in the hospital at this time. From the arrest affidavit, you could see that he has a serious medical condition. I believe he is still at the hospital dealing with that. We'd ask for a 24-hour reset, Your Honor.
Okay, and Officer Jenkins, is that why I don't have a cover sheet for?
Yes.
Okay. All right, so we will reset Mr. Nieves for tomorrow.
Thank you, Your Honor.
Rosalia Rivera, 22 MM 1997.
She is present and approaching, Your Honor. She has asked me to inform the court that she is a little hard of hearing.
Okay,
She's actually deaf, Your Honor, in one ear. And she has a hearing aid on, Your Honor.
all right, good deal. All right, ma'am, you were arrested for the charge of misdemeanor battery. There is probable cause for your arrest. This is an unfortunate set of circumstances. Do you have friends or family you can live with while this case is pending, ma'am? Yes. All right. It looks like this happened at your home, but you're going to have to maintain a separate residence from the listed victim. who is Christina Eglinton. You may return to 111 Barrington Road in Poinciana only one time with law enforcement to obtain some personal belongings. You must maintain a separate residence as long as this case is pending. All right. Going to order, I don't have a witness here today, so I'm going to order no contact with your daughter, Christina Eglinton, while this case is pending. I believe you may have a mother or mother-in-law living in the home. You can't contact.
Christina's my daughter, and I also have my mother living there.
Yeah, so you can't talk to your mother about Christina or send messages to Christina through your mother while this case is pending, okay? I'm gonna set your bond at $100 with pretrial release conditions based on the unique circumstances. Sade, is there anything else?
Nothing from the state, Your Honor.
All right, anything else, counsel?
Nothing from the fence, Your Honor.
All right, thank you, Bam. All right, Charmaine Sneed, 22 MM 1998.
He's present and approaching, Your Honor.
That's a very deliberate walk, Mr. Sneed. Sir, you were arrested for disorderly conduct and misdemeanor battery. There is probable cause for your arrest. I'm going to leave your bond set at $150 on count 1, $500 on count 2. You may not return to 1044 Cypress Parkway. You may not use any drugs, narcotics, or alcohol. And you may not have any contact with children under age 18 unless they are family members. You may not have contact with Evimir Jimenez Santana. All right, I think I've gotten everything. State, anything further?
Nothing from the state, Your Honor.
Mr. Messina, anything further?
Nothing at this time, Your Honor.
All right, thank you. Thank you, sir. All right, the next case, Scott Walsh, 22 MM 1999.
Your Honor, he's present and approaching. When we are finished with this case, may I readdress something that I just learned about a previous case?
Sure. All right, good afternoon, sir. Officer Jenkins, the arrest affidavit refers to an active warrant in another case, but I don't see any reference to that warrant. Does that have any bearing on this case? Was that a failure to appear warrant? Was that, looks like there was, but I didn't see a case today for that.
The one, he's out on pretrial release. He was on pretrial release, but it was revoked by another judge on 8/23/22. But he also will have another case for trespass, out of, Osceola County. And that's 22 MM 1585.
Right, and I'm curious as to why that warrant isn't in this packet, since he was arrested at the same, oh, it was a no information. That's why. No information was filed today. All right, so Mr. Walsh, you were arrested in this case for possession of marijuana less than 20 grams. There is probable cause for your arrest on this case. Your bond is going to be stayed at $250, okay? You may not use or possess any drugs or narcotics without a valid prescription. Okay, sir?
Your Honor, he may have a question. May I inquire with him for a moment?
Sure.
Your Honor, against the advice of counsel, he would like to make a request to the court.
Okay?
Your Honor, I would just like to advise the court that I am homeless and I've been born and raised in St. Cloud, and that I'm coming off an injury that I got in a car accident. And with that being said, I'd like to request, and I'm supposed to start a job today. With that being said, I'd like to request an ROR because I don't have any family or anyone, even any contacts to bond me out. And I'm supposed to start a job today. With that being said, I'd like to request an ROR.
Well, sir, I'm not going to give you an ROR for the reason that you don't seem to be a good candidate for ROR because you failed to appear in other cases. So you kind of created a track record for yourself, which is unfortunate, okay? So I've given you a low bond. That's the best I'm going to be able to do, okay? No return to 1125 New York Avenue in St. Cloud as the condition of the bond, okay? Thank you. All right, Amanda Billiter, 22 CF 2831.
Yes, Your Honor. Defense would have a probable cause argument in the next 3 cases,
Yeah.
Your Honor.
I can probably make it for you.
Thank you, Your Honor.
Yeah. All right. Ma'am, you were arrested on these charges, or in this case, rather, for possession of cocaine and possession or use of drug paraphernalia. There is no probable cause as to count 1. There is probable cause as to count 2, unless you have an argument as to count 2.
No, that was going to be my argument, Your Honor.
Okay. So you're going to be released ROR on count 1, and count 2, your bond is at $500. You may not possess or use any drugs or narcotics without a valid prescription. Okay?
Your Honor,
Yes, ma'am.
state is also requesting no weapons, firearms, as there's an allegation that firearms were located.
Didn't we address this? So was she not part of, because 2 of the individuals we had IAs for earlier this week. And didn't we address those then?
I apologize, Your Honor, I'm not familiar with.
Let me take a look. Yeah, Mr. Coates and Ms. LaHaley.
26,
I'm sorry?
26 of this month.
Your Honor, I have been informed by my client that she was IA'd earlier this week or late last week on a separate charge.
All right, let me take a look and see what conditions, because this warrant may, I don't remember if we discussed weapons last time. This warrant does address weapons.
Yes, Your Honor.
I recognize the names. And I've been on IA duty for 2 weeks. Maybe that's why I'm mixing my weeks. Clerk, is benchmark working? It doesn't seem to be working for me. Here we go. I don't see another 22 case for Ms. Billiter, so I will order that she not possess any weapons or firearms. Okay? As a condition of bond. Thank you, ma'am. Let me go look at the next case before I call it. Yeah, I don't think I addressed weapons and firearms previously. All right, Tariq Coates, 22 CF 2532.
President approaching, Your Honor.
All right, good afternoon, Mr. Coates. You were also arrested, sir, on the charges of possession of cocaine and possession of drug paraphernalia. Again, I find no probable cause as to count one. I do find probable cause as to count two. So you'll be released ROR on count one. Count two will be a $500 bond. No possession or use of drugs or narcotics without a valid prescription, and no possession of weapons or firearms. Okay, thank you. And then we have Ika Hilali. I apologize for butchering that name.
She's President approaching, Your Honor.
22 CF 2533.
Hi,
How do you pronounce your name, ma'am?
Aisha.
Aisha.
Yes.
All right, and your last name?
Lahilali.
Lahilali.
Yeah.
All right, I have to go very slowly. All right. Ma'am, you were also arrested on those charges of possession of cocaine and possession or use of drug paraphernalia. I find no probable cause as to count one. I do find probable cause as to count two. As with the other two individuals, you may not use or possess drugs or narcotics without a valid prescription, and you may not possess weapons or firearms. Your bond on count one will be actually an ROR, and your bond on count two will be $500, okay?
Thank you.
Thank you. And then our last two cases are Darren Shivers, 22mm 2000 and 22mm 1865.
Your Honor, he seems to wish to inquire with me. May I have one moment?
Sure.
Thank you. We're ready to proceed, Your Honor.
All right. Thank you. Mr. Shivers, case number 22MM 1865, you were arrested on a warrant issued by the emergency duty judge on the charge of violation of pretrial release conditions, domestic violence case. And in case number 22MM 2000, you were arrested for the same charge, different occurrence, but the same charge, violation of pretrial release condition in a domestic violence case. There is probable cause for both arrests. You are out on pretrial release in case number 22 CF 2378. So your pretrial release in that case is going to be revoked. You'll be held on zero bond pursuant to statute. That will be pretrial detention. In these cases, given the nature of the charges, your bond is going to be $5,000 in each case, with the conditions that you have no contact with Tanya Shivers. You must abide by all pretrial release conditions in all open cases. You may not possess any weapons or firearms. And based on conduct at the prior one-time return, I am not ordering a one-time return. All right. Anything else on those cases, State?
Nothing from the state, Your Honor.
All right. Mr. Mancini, anything else from the defense?
Nothing at this time, Your Honor.
All right, terrific. Ms. Officer Jenkins, anything?
No, sir.
Your Honor, if we may readdress one matter.
Which one is that?
Ms. Rivera, I was provided some information for the PTR officer here at the jail. She is also